guests. We welcome you to ASSOCHAM 9th International Summit on Corporate Restructuring, Merger Acquisitions and Joint Venture. Ladies and gentlemen, we have very eminent speakers, guests arrived over here. We are very sorry for short delay that happened due to this rain outside. People are in traffic. We apologize for that inconvenience. And I would like to briefly introduce and invite the dignitaries who have arrived here for this inaugural session. We have our guest of honor, Sri Sandeep Garg, IRS, Executive Director, Insolvency Bankruptcy Board of India. I would request and welcome you, sir, to move please towards the dais. Ladies and gentlemen, please give a huge round of applause to eminent guest of honor. We have a special guest, Ms. Jyoti Jinkar Bhanot. She is Secretary Independent Charge to Competition Commission of India. Madam, we welcome you. We have a special guest, CA Dr. Ashok Haldia, Chairman Board of Indian Institute of Insolvency Professionals of Institute of Chartered Accountants of India. We welcome you, sir. We have CS Ranjit Pandey, former President and Council Member, Institute of Company Secretaries of India. We have Sri S.C. Agarwal, Senior Member, Managing Committee, ASSOCHAM and Chairman and Managing Director, SMC Global Securities. We welcome you, sir. We have with us Mr. Vasudev Mukherjee, Assistant Secretary General, ASSOCHAM. We welcome you, sir. I may request and welcome, of course, the Chairman of the ASSOCHAM Task Force for Corporate Restructuring and Merger Acquisition, Mr. Pawan Kumar Vijay. Please welcome him. Join you, sir, please. I may request and welcome Mr. G.P. Madan, the Co-Chairman of the Task Force for ASSOCHAM Corporate Restructuring and M&A Council. He is about to join shortly. He is already there. Distinguished speakers, participants, ladies and gentlemen. Once again, I will request you to please welcome all the eminent guests on the dais, and also for your good self to arrive over here on the time. Thank you so much for joining us this morning. I welcome you once again. And to move forward, may I request all the dignitaries on the dais to please be part of this ceremony of the lamp lighting to begin with. Thank you. Thank you all the dignitaries, eminent guests for the inaugurating of this conference. Now I request all the guests to please take the seats in their respective seats on the dais. Ladies and gentlemen, as we move for the inaugural session, I would request the Task Force Chair for Corporate Restructuring and M&A, Mr. Pawan Kumar Vijay, to please present the welcome plant to our guest of honor, Mr. Sandeep Garg. Thank you. Thank you, sir. May I request Mr. G.P. Madan, Task Force Co-Chair, to please present the welcome plant to Honorable Special Guest, Madam Jyoti Jinkar ji. Thank you, sir. Thank you, ma'am. Now I request Mr. S.C. Agarwal, Managing Committee Member, ASSOCHAM, to please present the welcome plan to Dr. Ashok Haldia ji, special guest. Thank you so much, sir. Now I request Mr. Basudev Mukherjee to please present the welcome plan to Mr. Ranjit Pandey ji. Thank you so much. Ladies and gentlemen, in our day-to-day business language, we use words called change management. And in context of change, Mr. John A. Simon once said, if you are in a bad situation, don't worry, it will change. If you are in a good situation, don't worry, it will change. That's why we say change is the law of life, or change is the law of nature. The subject of this summit is an extensively applied strategy for inorganic growth and sustainability of organizations. Since the process of corporate restructuring, merger and acquisition and joint venture involves and undergoes massive changes, which involves various intricacies, implications to compliances or consequences to non-compliances under multiple regulations. Hence, the importance of this summit is unique as it focuses on to sensitizing the corporate participants and to all of us to understand how the process of change under the subject could be easier or how it could be tedious to handle. What are the associated costs in terms of time value and money for such changes? And let's go for deep understanding and insights and have a wonderful experience from the eminent speakers during the day-long sessions. As here we go, I would first invite Mr. Basudev Mukherjee, Assistant Secretary General, ASSOCHAM, to please give the welcome address. I welcome you, Mr. Basudev Mukherjee.
Mr. Sandeep Garg, Executive Director, Insolvency and Bankruptcy Board of India. Ms. Jyoti Jingar Bhanot, Secretary, Independent Charge, Competition Commission of India. Dr. Ashok Haldia, Chairman, Board of IIIP ICAI. Mr. Pavan Kumar Vijay, Chairman, ASSOCHAM Task Force on Corporate Restructuring and M&A, and Founder, Corporate Professionals. Mr. Ranjit Pandey, former President and Council Member, Institute of Company Secretaries of India. Mr. S.C. Agarwal, Senior Member, Managing Committee, ASSOCHAM, and Chairman and Managing Director, SMC Global Securities Limited. Mr. G.P. Madan, Co-Chairman, ASSOCHAM Task Force for Corporate Restructuring and M&A, and Managing Partner, Madan Law Offices. Distinguished speakers, and ladies and gentlemen. At the outset, I welcome all of you to the ASSOCHAM 9th International Summit on Corporate Restructuring, M&A and Joint Ventures, Recent Trends, Evolving Issues and Opportunities. The Indian economy has undergone massive transformation since 1991, when in the industrial policy comprising of liberalization, privatization and globalization was introduced. This resulted in license liberalization, foreign investment and technology, boost to the private sector and government disinvestments, amongst other things. The Company Act 2013 and subsequent amendments made thereto is the ground norm of regulating all the activities right from the entry to exit, including operations of corporate entities. The Act also provides for corporate governance norms and ensuring accountability to stakeholders. The last 10 years have witnessed big reforms in this sector. In furtherance, ASSOCHAM has been organizing a series of events on various subjects addressing the concern with an aim to help the organization grow inorganically. Mergers and acquisitions are used as instruments of momentous growth and are increasingly getting accepted by Indian business as critical tools of business strategy. They are widely used in a wide array of fields, irrespective of the sectors, as well as in traditional business, to gain through strength and expand the customer base to be competitive or enter into a new market or a product segment. Mergers and acquisitions are undertaken to access the market through an established brand or to get market share, to eliminate competition, or to reduce tax liabilities, or to acquire competence, or to set off accumulated losses of one entity against the profits of another entity. While there is much discussion on the ease of doing business, however, in the context of M&A, it is very important to ensure that the transaction deals protects the interests of not only the investors but also the other associated stakeholders. All the regulatory institutions are very much effectively taking cognizance of the evolving developments and taking actions from time to time and ensuring that the governance remains top priority and there is no place for compromises. I believe that in context of restructuring of M&A, if there is any further legitimate demands for consideration to the regulatory compliances or provision or sections under the laws which need to be relooked or reviewed, ASSOCHAM welcomes the inputs from industry and participants. Also, ASSOCHAM will ensure that all spin-offs from the deliberations from the summit will be collated and put forward appropriately to the consideration of the respective regulations and the government. Once again, I welcome all of you to this summit. Thank you.
Thank you, Mr. Basudev Mukherjee. Now, I would request Task Force Chair, Mr. Pawan Kumar Bijay, Chairman and Founder and Managing Partner, Corporate Professionals, to give the opening remarks, sir.
Good morning. Good morning. Welcome back after 3 years. We are meeting, so we should be very happy. So, good morning, friends. I just want that everybody should feel that we are back. So, good morning again. Good morning. Yes. Mr. Sandeep Garg, Ms. Jyoti Bhanot, Mr. Ashok Haldia, Mr. Ranjit Pandey, Mr. S.C. Agrawal, and Mr. Basudev Mukherjee, and other dignitaries and the speakers for the next session. Friends, as you are aware, that we are meeting after, I think, 3 years. We organized last program, and because of COVID, we are back. And so we are seeing so many faces, which was very familiar for all our program. And that's a good sign for human being also and the industry also. As you are aware, that COVID impacted everybody, personally also and business-wise. But in the process, we have learned so many things. Everybody, if you talk, they want to live life. They are realizing that the person who was with them, and suddenly we lost him. So everybody has shaken, and then they have planned that how to do this. So what happened? The same thing happened with the corporate also. The corporate also realized that why we are having so multiple companies. People have started thinking of succession planning. People have started various different thinking that how to bring business in a consolidated manner. And that's why if you see, the activity has started multifold. If I see the data, in 2017, we have $68 billion M&A transaction, including P. Then in 2018, it was 86, it was growing. But suddenly COVID has come, so we have seen in 1973 $1 billion, and then $82 billion in 2020. But last year, 21, we have seen a jump, and $114 billion transaction has taken place. Out of this, 62% was the M&A, and the remaining was the P transaction. We have seen the big transaction, the Air India transaction, the Pyramid had taken over this housing, Diwan housing. Then we have seen the SB energy transaction with Adani. So various new dimension we have seen, and the future is also very good. Everybody is realizing I should stick to my core, and the core word is directly connected with the M&A. So people are going for P funding, but simultaneously they are bringing out that how they can structure the organization so it can grow. So what is happening? Everybody today wants that non-core area should be out, and whatever core area they can acquire, they want to try. So these activities and this mindset will bring more and more work and more transaction. Now, if you see the M&A, because we have a committee here of M&A which is part of the corporate law, and we started so many things in this. Like we identified that this M&A is a complete thing, and in this so many issues are there. So that's why we formed a group, and in the group we are discussing various aspects. If you see M&A transaction, it is merger, acquisition, demerger, 192B, merger with subsidiary holding company, slum sale, P fund, various things are there, and everything has different laws. So if you see the law, if you want to do one M&A transaction, you have to undergo income tax, you have to see the legal aspects of all things, Companies Act, valuation aspects, securities law, if a listed company, then various securities law connected thing. Then we have a valuation aspects, because fairness of valuation issue is there. And if you see the agencies, you have to go to get the approval from income tax, you have to go to take approval from the stock exchange, SEBI, and then ROC, RD, and official liquidator. Then we require the valuation aspects, so the IBBI role is also there. Then we have a CCI. If you have to take permission of competitive things, then you have to go to CCI. So all these agencies are there when you do one transaction of M&A. Now the question is multiple thing, because what is happening? The M&A is a direct growth in a different manner. It's inorganic growth. You are just thinking how to take advantage of that 2 companies, 3 companies, 4 companies are there, how you can merge. Now from the chamber side, we always try to identify the issues, and today also when the program will take place, all the speakers, those who are coming from the industry and the practitioner, they will discuss about various aspects and various problems. And we will compile these problems and submit to the respective regulator. So the purpose of the program is that whatever point you have and you think, you please suggest during the program. Our ASSOCHAM team will note down all the points and submit. And that is the takeaway of you will understand what the speakers are saying, but ultimately we can talk anything. Ultimately the regulator has to finalize and regulator has to take action. Now, through this forum, I just want to raise certain issues which we want to take up. There is a possibility you may add this. The problem of M&A, I have told you, the various laws and various agencies. The first problem is we are facing an NCLT. The members are less, and then second is the merger is less priority than the insolvency. So whatever less number is there, their more main focus is on insolvency, that is a time bound. Though M&A is also time bound in the Companies Act 2013, they mention that everything should be time bound, but it is not happening. Next is it is not an aspiration on anybody, but this is one suggestion. What is happening? M&A is a complicated technical thing. It is not that anybody and everybody can do. Otherwise, all professionals should be involved in this. But the officer or the judicial member or the technical member, those who are coming, the knowledge of M&A requires more education. So sometimes what is happening, and because of understanding, these issues delayed. So these are the 3 points which we want to raise before the government. Then there is approvals. Now what is happening? We have to go to various approvals. So you have to go for approval for stock exchange, you have to go for approval of SEBI, you have to go to NCLT, you have to go for the RD, ROC, OL and CCI and various other things. So we want to propose that there should be a single window clearance and the government can make this plan. Next is SEBI and Companies Act. This is a contradicting or some duplicacy is there. 2 aspects I'm just touching. One is that you can file in, because as per company law, when you are filing second motion, then you have to take NOC from everybody. But SEBI provides that you have to take before filing to NCLT, and it takes time. Stock exchange and SEBI takes time, and it's sometimes 3 months to 4 months to finalize this. Another aspect which has added recently, the creditors' approval. So what is happening? Creditors' approval is a government, the NCLT advised that in the first motion you take the creditors' approval. But now SEBI is saying, before coming to us, you have to take a creditors' approval. So this is a duplicacy because you have to take here also, and then as per the company law or NCLT order, you have to take again. So this is a duplicacy. And the next, which is very important, which the ecosystem should develop, that there is no funding for M&A transaction. You are not allowed to take funding. Now how we will compete? We want to make India independent in economic aspects, but if you are not getting funding, yes, entire world is not giving funding, it's okay. But the other part is allowing funding. So the foreign company can take over any company in India because they have a fund and we cannot go. And the one more restriction which you must be aware on, you have faced the expended capital. Now what is SEBI is doing? If you merge listed company, then your holding should not cross 75%. And if you have a plan that the big company wants to acquire and they have to issue more share, then this problem is grave because you can't issue shares. In future also, you can't give warrant, you can't issue convertible instrument. They are saying whatever you are issuing for future, you have to calculate today, it should be less than 75%. This one law has created a problem for Indian company to acquire the good company. So these are certain issues which I have raised and we will discuss in today's session, and after that we will compile and submit to the government. So my further request to all the participants that please feel free. If you can ask question, it's okay. But if you want to write, you can give it to Santosh Parashar. And if you are not able to write today or you have some issues, you can pass on to us after the program from your office. We will compile and we will take action on this. And next program which we will do will specifically focus on the progress. So thank you very much, friend, and thanks and enjoy for today's session.
Thank you, Mr. Chairman of the task force. I may request our institutional partner addressed CS Ranjit Pandey. He is the former president and council member of the Institute of Company Secretaries of India. I would request and welcome you, sir.
Thank you, Santosh ji. Respected dignitaries, Sandeep Garg ji, Jyoti ma'am, Dr. Haldia, Pawan Vijay ji, S.C. Agarwal ji, G.P. Madan ji, former chairman Yogesh Gupta ji sitting in the audience, Mr. S. Abdul Rashid ji from Bangladesh, dear professional colleagues and all the delegates present here, good morning all of you. Good morning. इतना इंटरेस्टिंग टॉपिक डिस्कस कर रहे हैं. अब थोड़ा सा पवन जी का इतने अच्छे इश्यूज़ को रेज़ किया उन्होंने, सो थोड़ा सा हमारे को भी गेयर अप हो जाना चाहिए. सो फ्रेंड्स, we can see the rise in the M&A transaction in the year 2021, highest ever. And what could be the reason? Because just a year back, we were facing the pandemic. So that means pandemic has given the opportunity. And that was one of the most challenging time the mankind has faced, even industry has faced, because everything was shut down. We were not able to come out of the, say, even house. Despite that, say, transaction and M&A activities continued, and result of that is 80 deals has happened in the year 2021, and each measuring more than $75 million. So that is the magnitude we have seen, and we always feel that challenges brings the opportunity, and COVID-19 has given the opportunity, because what happened, some of the corporates or corporations has become weaker because of the lockdown. Some have become identified the opportunities has become more and more stronger, financially or otherwise. And that is why acquisition of or more and more M&A transactions started happening. So we can easily see that there is enough opportunity in the healthcare, technology space, infrastructure and pharmaceutical industry. But what government has proposed, that there should be structural reform in the coal, mineral, defense, production, civil aviation to boost the opportunity. If these reforms are going to be carried out, then more and more M&A opportunity is going to come in the future. And as Pawanji has mentioned in his, say, inaugural speech, that consolidation is the key, and core sectors are being consolidated. And one of the biggest example is HDFC. HDFC merger is, everybody was thinking whether Competition Commission of India will give the approval or not, but it has seen the light of the day, and it has been approved now. Similarly, you can see the example that Pharma Easy acquires the Thyrocare. Again, similar industry, it is acquiring and consolidating. Baiju acquiring Akash Educational Institute. So all these transactions you can see that consolidation. And if they do consolidation, then hiving off is also going to happen. It is imminent, because non-core will be hived off. So there is two transactions. One is one merger transaction, one is demerger transaction. So both happening, and there is more opportunity for we professionals. But opportunity is there, but whether we will be able to do justice to those opportunities, whether we will be able to unlock the value out of those transactions or not, that is the most important thing to be thought of by the professional. How to unlock the maximum value, how to give the maximum result to the promoters and stakeholders who want to go through this consolidation or hiving off the business. And friends, there are n number of steps which are involved in the M&A deals, M&A transaction. And so first and foremost important thing is that understanding the business and understanding the transaction. This is the most important thing. If we'll be able to understand the business, if we'll be able to understand the transaction and what should be the ultimate goal and outcome out of those transactions, then we'll be able to easily structure the deal. Structuring the deal is very, very important again, and by structuring the deal, we'll be able to frame the scheme of merger, demerger or restructuring, whatever the name called, under the Companies Act for the purpose of approval. Then comes the internal approvals, and problems has been shared by Pawanji that there are some gaps in the law itself which provides that approvals are required to be taken in such a manner. Friends, yes, we professionals are facing those problems, and we will be taking up, of course, with the help of the chambers also, we'll be taking it up with the regulatory and government authorities to have the more clarity in the approval process. Then comes regulatory approval. That is also a bit cumbersome. But nowadays what we are facing, more and more difficulty in NCLT. And why we are facing difficulty? Because of the IBC transactions, because IBC become the priority. What is required to be done? Of course, a strengthening of the benches, and more judges should be appointed to deal with the, say, this special transaction which creates value for the economy. So that is what is required. We have been called here as an institutional partner, and I am representing here Institute of Company Secretaries of India. And Institute of Company Secretaries of India is also grooming future M&A professionals, and we current company secretaries are also dealing with so many M&A transactions. There are n number of initiatives we have taken up individually and in association with the various chambers like ASSOCHAM, FICCI, CII, and all other say bodies, regulatory and government bodies. We have launched certification courses on this M&A, corporate restructuring. We have certification course on the NCLT approvals also, how to deal with take up the NCLT transaction, how to do it. Then we generally organize so many conferences and webinars. Webinars are now the buzzword everywhere, but thankfully we are shifting to the physical one, and it is more and more interactive, and it gives the sense of participation also and networking also. So that we are doing individually also, through web mode also, and with our associate partners like ASSOCHAM. I think last 10 years in the ICSI curriculum, we have full paper on the corporate restructuring, merger and amalgamation. This is with the intent to groom future professionals in time to come, and more M&A professionals or corporate restructuring related professional or expert, we should be able to produce as a company secretaries of India and give to the industry, so that they should not be facing any difficulty in dealing with these kind of transactions. As far as issues are concerned, I think more clarity is required in the policy. Government has done a lot of ease of doing business and changes in the policy framework. But as far as foreign direct investment in India, particularly land borders shared countries, which has been done recently, I think that is the good move, but policy clarity is required, so that we professionals should be clear that what is do's and what is don'ts. So that policy clarity is required from the government side. We will be definitely representing. Uniform stamp duty. Each and every state has the different stamp duty, different way of treating the M&A transaction. Some sort of brainstorming is required, where we should be able to dwell upon that what should be stamp duty on the scheme, what should be stamp duty on the movable properties, immovable properties, and all issuance of shares out of the M&A deal. Speedy approval is also one of the thing which is required to be done. Regulatory approvals we are getting well in time, but of course clearances at the time of NCLT is taking too much of time. That is required to be done. And last but not least, post-merger formalities. There are schemes which has been approved by the NCLT, say 6 months or 7 months or 10 months back, but still some of the clearances are pending. Post-merger clearances are pending, and because of that, we sometimes are not able to implement the scheme. So implementation of a scheme, if it is delayed, then it is loses its whole purpose. So that is what are required. So we are having the opportunity. We are encashing those opportunity, giving the services to the industry, and moving forward in the M&A transaction. So with this, I will be concluding my thoughts by saying that we at ICSI are always committed and to deliver the best of the services to the industry and best of the professional to the industry, and with the partners like ASSOCHAM, we will be doing more and more conferences like this. We'll be doing more and more seminars like this so that more and more knowledge can be shared with the professionals by the experts, and we will be becoming better and better professional to serve the industry. Thank you so much. Thanks for inviting me.
Thank you very much, Ranjit Pandey sir, for your kind enlightening words to the audience. Now, may I request CA Dr. Ashok Haldia sir, Chairman Board of IIIP of ICAI, for your special address, sir.
Very good morning, ladies and gentlemen. Indeed, a great pleasure to be here before you, and more so representing the Indian Institute of Insolvency Professionals. At the outset, I must compliment Mr. Pawan Vijay, as dynamic as he's always been, for organizing this program in a physical mode. And on such a vital subject, when Mr. Santosh rang me up for requesting me to be here, I was wondering what an insolvency profession has to do with a corporate restructuring, merger and amalgamation. This thought came at a flash of point as to there is no word like insolvency professional or IBC in the topic. But then when I looked into detail, I said, it's the important topic for the insolvency professionals. We have seen the IBC emerging from 2016. I was part of evolution of IBC way back early 2000 when we had was a part of a delegation to UK to study their insolvency regime. It has taken 16 years to come into reality. Another 5 years it has been. And we have seen debates how successful or unsuccessful it has been. In my view, the IBC 2016 was designed considering the ecosystem and the realities at that point of time of the economy, industry, the promoters, the banking sector, and in general. 5 years down the road, we have achieved possibly what we set out in the year 2016. One would wonder as to why one should first look at the ICU and also the liquidation of a company. But we were in 2016 in a situation where we possibly thought that we first need to address the cases which are in the ICU through the CIRP or through the liquidations. 5 years down the roads, the ecosystem has matured. IBC has been fairly and I would say largely successful. There are criticisms, but then I think those are not well founded. I have written, and I have been speaking over that. And now, possibly, what the time is that while it has achieved what it was set out for, time is now for IBC version 2. And a version 2 would mean the total redirection or again a holistic relook at the IBC, and which the IBBI is doing in terms of group insolvencies, in terms of cross-border insolvencies, in terms of individual insolvency, and in terms of how the value maximization can take place and how the time that is being taken, 473 odd days in resolution, can be reduced to the minimum. Now, when we are thinking all these things, the thought comes in my mind is why CIRP at all? If you are a mature economy, if you are a mature entrepreneurs, if you are a mature government, we should step in right at the incipient stage of the sickness and try to resolve that before it lands into an ICU. That's what a progressive society, a profession, or the economy would mean. And therefore, our focus should be on resolution before it went to ICU. And what are those things? Which I believe the IBBI is now focusing on, the pre-pack scheme that we have seen. And while one might argue that pre-pack has not been successful in terms of numbers, but look at the impact that it has had, the discipline that is brought into the minds of the lenders, the transparencies that they have brought into their settlement schemes, That has been a very positive aspect of the pre-pack scheme. And we need to look much beyond, and that would mean the mediation, that would mean these, the settlement, the resolution well before the CIRP. And to my mind, it comes the question of the corporate restructuring, merger, and the amalgamation. Can we address the sickness at the incipient stage, at a later stage, for whatever reason, when all the parties coming together, agreeing to what needs to be done, and then through the restructuring, merger, or amalgamations, now at least one has to follow the process for all these and see that can it be revived. And therefore, not only the time taken resolution would be reduced, but the value maximization would also take place. That's precisely, I would believe, is, and once it goes into CIRP, a resolution professional has a key role to play. He is not as simple a facilitator of the insolvency process. He has to apply his mind. He has to have expertise. He has to have a multidisciplinary approach and multidisciplinary expertise. He has a multifaceted role. He's an executor. He's a mediator. He's a negotiator. He's the compliance. He's the arm of NCLT in that sense, and also a fulcrum of the entire IBC. I often said that the IBC may not be successful if the IP fails, if they are not able to generate the trust and confidence, that credibility that the stakeholders would expect from them. And in this entire process, while the Vijayji and Ranjitji has said that the number of cases of merger and amalgamation that has taken place in India, but look at the IBC. All the cases are either resolutions, or the merger, amalgamation, or the acquisitions, or the new investor coming into, or the restructuring taking place. Now, if the resolution professional is not aware of nitty-gritties of restructuring, the scheme, the negotiation, the articulation, the presentation, the compliance of law, the complexities of the law, how to negotiate through them, the CIRP may not be successful, and it may be a failure. And I often said, and I believe, having read merger and amalgamation and restructuring for a long, and be part of some of those cases, that it is much more than mere preparing a scheme, becoming a buyer, bringing together buyer and seller on a table. It's a meeting of minds. It's a meeting of hearts. It's like a marriage. Marriage doesn't end with the marriage function or the feast over the marriage. It starts from there. Now, if the mind doesn't meet, the heart doesn't meet, the marriage is not successful. And it might have a fatal consequences. And so with the merger and acquisitions. And therefore, those who deal with the merger and acquisitions have to be fairly acquainted with the art of merger and acquisitions. Then also the science is important in terms of compliance, in terms of structuring, in terms of financials, in terms of the cash flows, in terms of viability, in terms of what happens 5 years down the road, how the global trends are emerging in that area, and maybe as Pawanji said, focus on the core areas. There was one time there was a wave of diversification, diversifying into unrelated areas. But possibly thinking has come that confined to your core competencies. But when you confine to your core competency, you expose yourself to multitude risks. Now, those are the challenges. Now, as an insolvency professional, when one looks at the merger and amalgamation schemes, he has to have a forward-looking approach. He has to look at the risk, associated risk. Is it not simply an acquisition? Because at a low price or low value, the corporate debtor is available, or it has a long-term value. It really adds to the economy. It really adds to the stakeholder. So I believe this topic of the day is very valuable, very important from an insolvency professional point of view. And I would request Pawanji, some point of time, maybe together with the IIPI, we organize a program exclusively for insolvency professionals as to what does it mean, what is their role into this area. And often they believe that we are here to comply with the law. We are here to box-ticking approach, what the IBBI would expect, or maybe what NCLT would expect. But possibly their role is much more vibrant, much more challenging than simply compliance. So with that, thank you very much for inviting me, and I'm indeed grateful. And in fact, the number of issues and challenges that have been identified, these are issues and challenges, I would only say they are there for decades, and we have not been able to address them. Time has come where some will and determination is there, I would believe, in the government, and we have Mr. Sandeep Garg from the IBBI and Madam from Competition Commission. I'm sure they would take these issues, and particularly the issues related to NCLT. I'm not saying the NCLT members are not competent. They are competent, but then it's a different ball game. Merger acquisition, corporate restructuring, I have explained, is a different ball game. You need to go into depth. You need to go into the spirit and letter of the merger and amalgamation scheme, not only mere by the eyes of the law. And then you need to take a call. So you need to have exposure. You need to have specialized benches which are able to devote and which are able to dispose of within the reasonable time, as the IBC has been amended or is going to be amended with the resolution plan timeline from being increased from 45 days to 54 days. Well, 9 days, it might mean the quality of information that goes into the resolution plan and to the committee of creditors improves when their merger and amalgamation and corporate restructuring is involved. It would improve only when those who prepare those resolution plan, those who read it, those who understand it, those who take decision on the such resolution plan, understand what the corporate restructuring, what the merger and amalgamation is there. And therefore, these kinds of programs not only important for the professionals. Professional, in any case, they know somewhat about the restructuring, merger and amalgamation, but possibly what is important is the other stakeholders. They do need to understand and appreciate what these terms are and what does it mean in order that these are successful. Thank you very much, ladies and gentlemen.
Very much, Dr. Ashok Haldia, sir, for your special address covering extensively the IBC and professionals' concerns and issues. We look forward to your guidance further on this subject, sir, as well. Ladies and gentlemen, may I request you to please welcome our another special guest over here, Ms. Jyoti Jangar Bhanot. She is Secretary Independent Charge, Competition Commission of India. We welcome you, ma'am.
Dignitaries on the dais, eminent speakers, distinguished panelists, ladies and gentlemen, a very good morning to all of you. It gives me immense pleasure to be here in person in your midst, and it has been a delight to listen to such eminent speakers who have covered multi-dimensional areas of this very important topic of mergers and acquisition. And at the outset, I compliment ASSOCHAM for having organized this conference and have brought together people, I think, from across the stakeholders, the regulators, and the practitioners, corporate professionals, which I think will definitely provide a wide variety of perspective. So inorganic growth, as we all know, is fundamental means of growth and efficiency. In a transitional economy like ours, it assumes larger significance in re-engineering capacities, facilitate technological transfer, mobilize capital, and build competitive businesses at global scale. Friends, to a large extent, the issues and trends in mergers and acquisitions actually mirror the trends in the economy. And the M&A landscape in India is dynamic, and activities have witnessed a quantum jump across the sectors, as has been mentioned by various speakers. And in fact, in the last 2 years, in the wake of pandemic, it has seen a paradigm shift in the way the industry functions and has given rise to novel issues and challenges for regulators and policymakers. The need of the hour is to have a healthy market environment that facilitates corporate restructuring and mergers, and it is imperative for the regulators to have a proactive engagement with stakeholders to evolve system and practices that balance facilitation and enforcement. And I think this is a view which has been echoed by the speakers and the demand from the industry as well. So let me begin by talking about the philosophy of the competition merger control regime, because CCI as a regulator has been given a mandate to implement that. So globally, only a small number of combination cases are found to pose competition risk. However, this small number of cases could result in irreversible damages to market structures, affecting price, quality, and innovation. Thus, the regulatory philosophy of the antitrust agencies of a light touch regulation has been to identify cases that merit in-depth examination, and in the rest of the cases, reduce compliance requirements to the minimum. And the competition law regime in India is also grounded in this philosophy, following the best international practices by focusing on building a pro-market framework for regulation of mergers. And this, in fact, is reflected from the very architecture of the law itself, which requires only very few transactions which meet the thresholds, various thresholds, which could be at the level of India, at the level of global thresholds, or as a group, only very small set of transactions which are fulfilling those thresholds are required to be filed, are notified, and which are then assessed from the competition law perspective. And apart from that, there are exemptions which are the local nexus exemptions, thereby meaning that only when they have a presence, significant presence in India, and these exemptions are there in terms of turnover and asset, reflecting the presence in India, only those transactions are required to be filed. Government from time to time has also exempted certain class of transactions from notification, and also through our regulations, we have notified various categories of transactions which are not ordinarily expected to have appreciable adverse effect on India. We have basically done away with the requirement of notification. So overall, the philosophy has been to focus only on those transactions which are likely to have any implication from the competition law perspective. And apart from that, competition law also being an economic law, the assessment factors in fact, the law itself prescribes how we can take into account the various efficiencies which are emanating out of the merger in carrying out the assessment. So if you look at the decade-long experience of CCI, around 950 combination cases have been filed so far. Remedies have been issued only in 23 cases, and these are both behavioral and structural remedies. And and only to the extent while designing these remedies, due care is taken care to ensure that the remedies are proportionate to the problem which the Commission seeks to address. And in fact, only very few cases have been subjected to detailed investigation, and the average time taken to approve the merger has been around 18 working days in normal cases. So all this overall, I think, reflects the approach of the Commission and the importance that the regulator attaches to this activity, and how it is recognized that they are a very key instrument for the growth of the economy. And in fact, as part of its ongoing and regular efforts to make merger and acquisition filings and approval faster, CCI keeps on reviewing and updating its processes. Over the last few years, several changes have been made to the combination regulation with a view to provide certainty, reduce compliance requirements, make filings simpler, and aligning with the international best practices. And to mention a few, the introduction of Green Channel route, which many of you may know, allows for an automatic approval of combinations that have no overlaps. In fact, this is the first of its kind of a trust-based assessment system, which has been introduced in India, and it has been widely recognized globally, and the industry has also adopted it, as can be seen by the increasing number of cases which are being now filed through this route. In fact, the forms for notifying combinations have been significantly simplified. The overlaps or repetitions have been done away with, and a lot of clarity has been provided in terms of the supporting guidance notes which are there. The requirement of providing non-compete information in merger filings has been dispensed with, giving parties flexibility to negotiate non-compete arrangements besides reducing compliance costs. So all this indicates the hand-holding approach and the light touch regulatory approach. Now, coming to the digital markets, which I think now are seeing across the economy. Merger control in digital markets has been a subject matter of particular attention across the agencies and a vibrant debate recently. For instance, from the competition point of view, acquisition by big tech in digital markets may cement their market power, besides potentially preventing targets from emerging as a competitive threat. So such transactions may require a close scrutiny from the competition law assessment perspective, which is, of course, a challenging task. And it is evident from our experience that digital markets and platforms are of various kinds, so are the nature of transactions. Not all digital markets are alike, not all data is alike, and not all transactions are alike. So our effort in our merger control regime has been to understand the specific circumstances, business models, strategies, the rationale of the transaction, and the counterfactual scenario. And this is, I think, what was also mentioned, that how critical it is to understand the market and the transaction. And of course, it is critical from the point of view of the entities who are going through that transaction. Similarly, for any regulator to make a very careful intervention, it is very important to really understand the various dynamics of the transaction and what are the potential areas of concern. And the legal framework set out in Competition Act for determination of appreciable adverse effect on competition, fortunately, is broad enough and gives us the flexibility to develop and test all such theories of harm that may be relevant in digital markets. And as I mentioned earlier, now these remedies could be both behavioral and structural remedies, keeping in mind the transaction and the competition issue which has emerged in the case in question. The interventions are guided by case-specific economic evidence of competition concerns, and the same holds true even in digital markets. So in a nutshell, CCI is responding dynamically to the changes in the merger and acquisition landscape, particularly on account of the emergence of the new age markets. So before I conclude, I would like to talk about the amendments pertaining to merger control regime proposed by the Competition Amendment Bill, which was introduced in Lok Sabha recently and has since been referred to the Standing Committee. Now, this bill is an outcome of the recommendations made by the CLRC, Competition Law Review Committee, which was set up in 2018 and submitted its report in 2019. And after extensive public stakeholder consultation, the Ministry of Corporate Affairs came out with this bill to keep up with the changes market scenarios and the pace of the industry. And to meet the needs of the stakeholders, these amendments have been proposed, and I will highlight some key proposals from the merger control regime perspective. purchase of securities in stock exchanges, which are unlike negotiated transactions, they are traded on anonymous basis, and the price of such securities is volatile. Therefore, time is the essence for these kind of transactions, and these cannot be basically postponed or kept on hold for the need of approvals. And the cost of acquisition can therefore also go up in a matter of few minutes. Now, as per the Competition Act, parties proposing combination have to notify the same to CCI for approval, and they cannot implement their combination until the approval of CCI is obtained, or 210 days, whichever is earlier. So, presently, these provisions equally apply for purchase of shares through stock exchanges as well as purchases through a market purchase or an open offer. So now, to address these eventualities, the proposed amendments seek to establish a special framework for market purchases. And under this framework, parties can conduct market purchases without prior notification and approval of CCI. However, the parties would be subsequently required to give notice to CCI within the specified time, and would not be able to exercise any ownership or beneficial rights or interest in such shares till its approval. So this proposal will, I think, very nicely strike a balance between the regulatory concern and also a very genuine bona fide need of the industry. And that's why the importance of stakeholder consultation and arriving at innovative solutions which can take care of the concerns and address the difficulties faced by the industry. The bill also clarifies the scope of asset and turnover to be considered for the purpose of ascertaining whether the transaction meets the financial thresholds, and clarity is the essence and very much required for the industry to basically avoid any non-compliances. The bill reduces the timeline for inquiry into combinations from 210 days to 150 days. A lot was said that how critical the time is in terms of mergers and acquisitions, and this change, I think, should go a long way in addressing that concern. So now, one very critical change from the perspective of the new age markets, particularly from the new age market, is the proposal to introduce a deal value threshold mechanism for notification of combinations. Under the present framework, merger and acquisitions which are required to be notified are on the basis of the assets and turnovers. However, very often, particularly in the new age markets, what is being found is that the assets and turnovers may not really reflect the market power of the entities which are involved in the transaction. The market power may actually be arising out of the kind of data that they have, network externalities, therefore, and so on. So therefore, it is very important that these, some of these transactions which actually require scrutiny from the competition law perspective are not left out of the net. And internationally, there have been a lot of changes, or the regulators have responded either by looking at these transactions post-combination or coming out through ex-ante rules. And one such approach has been to come out with another threshold or another metric in terms of the deal value threshold. And the new bill also proposes this new threshold based on the deal size of the transaction. And of course, this regulations, if approved, regulations will bring out that how this deal value threshold actually will be arrived at. It most likely will have to be on the basis of market-facing parameters, which could be in terms of the number of users, number of contracts, which actually reflect the areas which translate into the market power. So I believe that the proposed amendments are significant and developments towards ease of doing business, at the same time will empower the Commission to sustain and promote competition in the next generation markets for the good of all stakeholders. Lastly, I may mention that CCI is also putting a lot of emphasis on developing and constantly updating the knowledge about new age markets for better understanding of the business models, underlying incentives, and impact on competition of the notified transactions in this space. With these words, I would conclude, and I have gone through the agenda and the various sessions which are lined up, and given the quality of in speeches, I'm sure the sessions will see very stimulating discussions. Thank you so much, and I wish the conference a success.
For your special address, extensively covered the competition perspectives on the subject. Now, ladies and gentlemen, may I request you to please welcome our guest of honor, Sri Sandeep Garg, IRS. He's the Executive Director with Insolvency Bankruptcy Bureau of India. So I request and welcome Sandeep Garg, sir.
So, dignitaries on the dais, organizers, and participants to this international summit, very good morning.
Good morning.
So, 9th International Summit on recent trends, evolving issues and opportunities in corporate restructuring, M&A and joint ventures, gives me an occasion to pitch to all of you the opportunity resolution in insolvency resolution provides to all of you. It also gives me an opportunity to state that we at IBBI are aware of the various concerns of the market in respect of the time taken for approving the plans, ensuing litigations, and we are deliberating the steps that can be taken to address them. First, let me give a little backdrop of the scenario prevalent before the Insolvency and Bankruptcy Code, IBC as we call it, came into existence. Not in the distant past, the insolvency processes in India were governed through a highly fragmented framework with the powers of the creditor and debtor being provided by different legislations and being adjudicated in multiple judicial fora. For example, Sikh Industrial Companies Act 1985 focused on revival of Sikh industrial companies. It looked at the problem from the perspective of the Sikh company and the workmen employed. During this regime, type 2 error was committed, wherein companies that were not viable were continued for long. The Recovery of Debt due to Banks and Financial Institutions Act, RDD BFI Act, was enacted in 1993 to make it easier for banks and financial institutions to recover debt. After another 10 years, SARFAESI Act was enacted to make it easier for secured creditors to recover their debts. Both RDD, BFI, and SARFAESI were created from the point of view of creditors' recovery. In these acts, there are higher chances of committing type 1 error, where even viable enterprises are forced to wind up because their productive assets are taken away. Further, since the implementation of these acts required different judicial fora, the process was long drawn. In a situation when one forum is deciding on the matters relating to the rights of creditors and another forum is deciding the rights of debtor, the decisions were readily appealed against, stayed, and overturned by higher courts. So there was a need for comprehensive legislation which focused on resolution of debtors while taking care of interest of creditors. The enactment of IBC in 2016 marked a significant departure from the prevalent approaches. The code recognizes that insolvency is an outcome of market forces. It incentivizes, facilitates, enables, and empowers market participants to resolve insolvency. The first order objective of code is resolution. Only in cases where market is not giving a viable resolution plan, liquidation is resorted to. So this approach tries to minimize both type 1 and type 2 errors. IBC offers a market-directed, time-bound mechanism for resolution of insolvency wherever possible or exit wherever required. The code strives to provide for the best sustainable resolution. It envisages limitless possibilities of resolution through a resolution plan, including restructuring by way of merger, amalgamation, or demerger. In a very first case, resolved under IBC, the resolution plan proposal by Synergy Castings Limited for Synergy Dore Automotive Limited contemplated merger of SDAL with SCL. While upholding the order of NCLT approving the resolution plan, the appellate tribunal, NCLT, held that IBC is a code by itself and Section 238 provides overriding effect over the provisions of other acts and rejected the argument that merger or amalgamation of the companies cannot be proposed in the resolution plan. So there are some unique advantages in the code. I will deliberate upon them, which make it most potent restructuring frameworks in India. So first of all, it provides limitless possibilities of restructuring. A resolution planned under IBC may entail a change of management, technology or product portfolio, acquisition or disposal of assets, businesses or undertakings, restructuring of organization, business model, ownership, strategy of turnaround, buyout, acquisition, turnover, and so on. While doing so, it ensures that company runs as a going concern so that the value of the company is retained. The code envisages resolution of the firm as a going concern. As closure of the firm destroys organizational capital. It facilitates continued operation of the firm by moratorium on institution or continuation of suits proceeding against the firm during the resolution period. It prohibits suspension or termination of supply of essential services to the firm to keep it going. It prohibits any action to foreclose, recover, or enforce any security interest during the resolution process. And it thereby prevents any productive assets to be taken away. It enables raising interim finance, which has been provided super priority in payment. This resolution process, during this resolution process, the facilitation in due diligence is done by an independent insolvency professional. So one of the most important exercises which is conducted during a M&A process is due diligence. In insolvency resolution process, it is the independent insolvency professional who is managing the company and the processes. So he facilitates due diligence instead of the interested promoters. So this facilitation by an independent professional is likely to be more objective. Then, coming to the most important aspect in which many resolution applicants are appreciating is the binding nature of the resolution plan and the clean slate principle. Resolution plans approved by NCLT is binding on all stakeholders, including central government, state government, any local authority to whom any statutory dues are owed. The company becomes free from any past liability, and the liability of a corporate debtor for an offense committed prior to the commencement of insolvency process ceases if the resolution plan results in change in management of the company. But there have been several challenges, and there has been mounting pressure. We have to deal with them. I'll come to these challenges and how we are deliberating, what action can be taken against in respect of them. So despite these structural advantages which I had enumerated, there are several challenges which require a lot of reforms. And I can assure you that both the government and the board are actively working for the same. There have been delay in approval of resolution plans. Some recent judgments have put a question mark about the finality of the resolution plan and inter se priorities among creditors. One of the main reasons for causing delays in approval of resolution plans has been large number of interlocutory applications which are filed, and some of them are filed by competing resolution applicants. Being an industry forum, I will request that you may deliberate, probably today, that how can we reduce litigation of this type. So I'll just cite a recent case of a resolution of a steel company in Indore, wherein NCLT has halted the voting process and permitted the resolution professional to invite a fresh offer after a resolution applicant approached them that it is willing to provide a better offer which will improve the creditor's recovery. The other applicants have objected to the NCLT and challenged it before ANCLET. Many lenders then questioned why the applicant went to NCLT to stop voting when it did not improve its offer in the Swiss auction, which was being held during the process. Such disputes and objections are very frequent. Almost every big case is facing them. So one can see the self-interest of the party in such an action. But in the end, no one wins, as the plan gets delayed and litigation mounts, because the other party also resorts to litigation. Resolution applicants as a whole, as an industry, are the biggest loser, because the return which was going to be available in 1 year can't even be realized in 3 years. So ASSOCHAM, being an association, may take an initiative to evolve a code of conduct by following which the whole industry wins. Another measure which we are considering and deliberating is, can we divorce the distribution of the proceeds of the resolution, the plan, from the implementation of the resolution plan. So there are two types of interlocutory applications which are challenging the plan. Few of them are disputing that which plan will win, and several are in respect of the distribution of proceeds of the plan. I should get a larger share, I should get a more priority, that kind of a thing. So we are deliberating how the two can be separated, so that the application in respect of choice of resolution plan, they are decided first, and then the approved resolution plan can go ahead. And the disputes about the distribution of proceeds, they can be taken up later. The disputed amount can be kept in an escrow account, and the rest can be distributed. Amount kept in an escrow account can be distributed when such applications about the disputes are decided. So in doing so, the assets will become productive much earlier, contribute to the economy, and they will result in better gains to the resolution applicants as well as to creditors. We are coming up with regulations soon, which will allow resolution plans to be submitted for parts of the business. Businesses may be operating different units at different locations. A company may be having different types of businesses. One resolution applicant may be interested in one location, or maybe in one particular business, may not be interested in other parts of the business. So we are coming up with regulations that will allow these part businesses to be offered to different types of resolution applicants, and then come up with a combined resolution plan. with several resolution applicants. Talking on interim finance, this is also a very important issue. This is basically a short-term, super secured lending for a short period of, say, 24 months. This for the companies which are undergoing insolvency. And this is used to keep the companies under insolvency running as a going concern. Legal Pay, a tech-focused startup, is investing in commercial litigations and providing interim finance. They have identified this interim finance as a moderate return, low-risk investment in view of its super priority. So I hope more players will analyze this and come forward to provide interim finance. Then another issue which I would like to deliberate all of you is that how can we create a better marketplace for stressed assets? How can we provide better information to the resolution applicants, which leads to better discovery of assets and thorough due diligence? I can assure you that all your suggestions and recommendations will be considered at the earliest. Like everything else, this reform also has to keep evolving. The key thing to remember is that embracing the future is not an option, but a necessity. IBC has kept pace with emerging market requirements by frequent amendments. It will continue to do so, and so that it remains pertinent for all times to come. I hope and believe that various panel discussions in the summit will provide us useful insights. I thank ASSOCHAM for providing me and all of us this wonderful opportunity to interact and discuss the relevant topics. Thank you so much.
Very much, Sandeep Garg sir, for your extensive kind words in the speech of guest of honor. I'll just take a minute time. As far sir mentioned about the IBC code, when it was early in 2016, it was being developed over, and then comments were being invited. We were the first industry body from ASSOCHAM, wherein Pawan sir, Madan sir, along with Dr. M.S. Sahu sir, we invited the comments from the general public and the industry by large and submitted, and contribution was from ASSOCHAM side in that perspectives. So far, Ranjit sir mentioned about uniform stamp duty. I remember that we have already raised in 2020. We have submitted this to Finance Ministry as well. We remember the time back when we initiated the One Nation, One Duty. Subhas Agarwal sir, he was there, and he addressed this and taken up the point of One Nation, One Duty. And this uniform stamp duty could be a game changer as well. Thank you very much, and I would request Madan sir to further please give your comments quickly, and then I would request Subhas Agarwal sir for your concluding and vote of thanks for this session.
Thank you, Santosh. You have already said quickly. Good morning, everybody. All the dignitaries on the dais, off the dais. Welcome to this 9th International Summit on Corporate Restructuring. And I have privilege of having been associated with all these 9 summits. Thank you. Jyoti ma'am, you talked about CCI role in merger and amalgamation. I think there are 3 regulators in every M&A scheme. Normally, if it's a listed company, depending upon the size and all that, SEBI, MCA, and CCI. We, the stakeholders, have been criticizing some of the provisions and the processes which are being followed by Ministry of Corporate Affairs or ROC or Regional Director or SEBI or Stock Exchange. But I don't think anybody has raised any question on the functioning of CCI. That's what my personal feeling is, because the time which you are taking is very, very less. And within the timelines, you are approving all these combinations, sir. And you talked about this proposed bill also, which is there, and consultative process for last 2 years that has taken place. I really admire the way the government is functioning nowadays, whether it's a CCI or MCA or even IBBI. Even every amendment is being routed through the stakeholders. Even I admire Mr. Garg that for every damn regulation you are coming out with a discussion paper. Discussion paper is thrown open to the public. In-house meetings are also held, and then only you come out with the amended and revised regulations. Haldia sir, you talked about insolvency professional. What you said, what is the role of an insolvency professional in this corporate restructuring? Sir, the role will emerge the moment you say insolvency professional as insolvency resolution professional. Automatically the resolution word is nothing but restructuring. And actually I make a request to IBB also to consider this, whereas insolvency professional should be called as insolvency resolution professional. Because I have two instances with me. Number one, to begin with, there was SFO, serious frauds offices. Then it was changed to serious fraud investigation offices. Investigation, what was that later on? Otherwise, it was called serious fraud office. And second example was SEBI, insider trading regulations. The word prohibition was added later on. So say here also, if we say insolvency professional, that may not give a right signal to the stakeholders that is he leading to insolvency or he is going to resolve the insolvency of the corporate debtors, if that can be thought about. Haldia Sahab, you also talked about that there is criticism of insolvency and bankruptcy code. And rightly or wrongly, I'm not going to comment on that, but I'm a strong supporter of IBC. Why their criticism has been there? The criticism has been there because of the two things, according to me. Number one, that the cases which have gone into CIRP, ultimately 80% have gone into liquidation and 20% only into resolution. But actually that's not the fact, because out of the 80% which have gone into liquidation, as per IBB report itself, 75% of them are erstwhile BFR cases. They had no other option but to go into liquidation. But I am very sure this figure is going to reverse very soon. Second, the criticism of IBC has been there because of delay. And the delay is not on the part of MC or on the part of IBBI. The delay is on the part of adjudicating authority or on the part of COC. But as far as adjudicating authority is concerned, actually they are also having their own limitations because the number of benches and the number of members. But that problem is going to be resolved very soon, I'm sure. Within next 1 month or so, 15 members are going to join NCLT, and maybe another next 3 to 4 months, another 15 are going to join NCLT. So 30 new members will be there in NCLT, and I'm sure this delay will be the thing of the past. Another thing, the number of fresh cases is getting reduced. Thanks to 1 lakh to 1 crore. Section 10 cases not being admitted. And under Section 7 also, sir, because of the latest judgment of Supreme Court, maybe Section 7 banks may also not come forward to file fresh cases. But sir, there, Sandeep ji, there I have a suggestion. We need one small amendment in IBC. One small amendment, just insertion of one word. I'll discuss with you later on. Just insertion of one word, and the whole issue which has been created out of the rainbow paper case by Supreme Court can be resolved. Just because of one simple amendment. And I think I'll discuss with you, and MCA can come out with that ordinance to begin with, and then later on the amendment can be brought through the parliament process. Some of the other issues, Baldia Sahab, I really liked it, you talked about IBC version 2, group insolvency, cross-border, and the third amendment which I need, the need of the hour is mediation and arbitration under insolvency and bankruptcy. I think that will also resolve. Rajaranji, you might be having your own views, but I am a strong supporter of that, and that can play its own role. I have deep study on this. I'll discuss with you later on. And actually, though it's not a platform to be shared, but my son has also come out with a book on, international book on international arbitration insolvency that is going to be released on 27th of this month. I'll share with you what is the text of that, content of that book. Uniform stamp duty, Ranjit ji, you said. But along with the uniform stamp duty, I think in M&A we need to have uniform practices also to be followed by the adjudicating authority. Very recently, I myself have observed that in a small merger case of holding company with its 100% owned subsidiary companies, the court is not allowing dispensation with the holding of the shareholders meeting. They say where it is provided in law. Section 230 subsection 9 talks about dispensation of creditors meeting. It does not talk about dispensation with the shareholders meeting. Though there are number of judgments which have been pronounced by National Company Law Appellate Authority, despite those judgments, the NCLT says, no, sorry, you have to hold a meeting. And if you hold that meeting, another 3 to 4 months are gone, and it's a time-bound, it's an expensive process also. Then they are appointing chairperson, alternate chairperson, and the scrutineers and all that. I think we need to have, across India and all benches, we need to have uniform practices for these merger and amalgamations. And last but not the least, there are a number of issues to discuss here, but last but not the least, no, 2 more points. Haldia Saab, sorry to interrupt you. You talked about time-bound resolution plans. For that purpose, recently NCLT principal bench has come out with a novel idea. And now they have circulated a format of the draft orders to be passed. Draft admission order in the beginning and draft resolution plan approval order. And the resolution professional, while filing this application, has to submit this draft order. That is really going to save the humongous time which has been taken by the adjudicating authority. This used to happen before many high courts in merger and M&A cases, but that's going to happen, that's going to be reality in NCLT also. And Sandeep ji, ek aur mera suggestion hai ant mein. You said that due diligence by resolution professional, sir, that is to be given a finality. Because you have brought about section 29A under IBC to prevent the willful defaulters to submit a resolution plan. But sometimes they try to submit a resolution plan through backdoor. And if the resolution professional is saying, no, Mr. So-and-so, you are not eligible, and there are a number of instances where COC says, no, he is eligible, because there is some connection between COC and this resolution applicant. If resolution professional says you are not eligible, COC says no, you are eligible, and there are a number of court pronouncements, sir, where it has been held that COC is the final word. Though that is not part of the code, that's not the spirit of the code. And in those cases, those promoters have had a backdoor entry. Sir, we need to give complete authority to the resolution professional, or if required, the work may be assigned to an outside professional, but not to COC. With this, friends, I'm very, very hopeful if, abhi taali mat bajao, please. Regarding the success of IBC, as I said, I'm a strong supporter because IBC has brought discipline amongst the borrowers. Nowadays, the moment a demand notice comes, whether from an operational creditor or from a bank, the moment a default is there, very next day, the borrower rushes back to the lender or to the creditor and tries to settle it down. Actually, the figure जो हमारे सामने आती है ना कि इतने cases हुए resolution profession CIRP में, actually more than 6 lakh of crores has been recovered by the creditors immediately on filing of the application and before admission of the application. Actually, that figure is not amongst the public. क्योंकि कहते हैं negative cells, कई बार negative चीजें फैलाओ तो बहुत अच्छी लगती हैं. But positive side is that lakhs and lakhs of crores has already been recovered because of IBC. And I'm very sure the moment we have this entire infrastructure in place, this insolvency and bankruptcy code, not in the CIRP but also in the M&A sphere also, is going to create wonders. Thank you very much. Thank you.
Thank you, Madan sir, for concluding remarks. Just for your reference, you mentioned about the mediation and arbitration. Earlier we had, there are 2 councils at ASSOCHAM, which is among Those one is the ASSOCHAM International Council for Alternative Dispute Resolution, and another is Arbitration and Mediation National Council. I remember recently in the one of the past conferences, Dr. Ashok Haldia sir has taken this up about the arbitration and mediation, and you were also part of that particular conference wherein Justice former Chief Justice of India, Mr. Justice Deepak Mishra ji, he acknowledged and the need of this particular arbitration that can help the industry at large. So we are in process of that. We would further seek the guidance from your good self as well as the other professionals. What should be the way forward to propose to the government as well? And I'm supposing that very soon I'm going to meet with the secretary and the joint secretary in the Ministry of Law. So I would request to join us for that meeting to take this forward and make this happen actually. I would request now Shivas Agrawal sir to please come and give the concluding and vote thanks. I request all of you to please welcome Agrawal sir.
Good morning, everyone. Good morning, on the dais and of the dais. I think Mr. G.P. Madan has already summarized the good points and of all the speakers. So my job he has made very little now, and time has so much there. It's good. First of all, I would like to congratulate ASSOCHAM for organizing this seminar. It's very rightly seminar because lot of merger acquisition deals is being taken off recent times, as was quoted by Mr. Pawan Kumar Vijay, that in 2020 it is 82 billion US dollar PE and merger acquisition deals. In 2021 it increased to 140 billion US dollar. So and more than a figure is not available, but in 22 and 23 it will be much more than that, because a lot of merger acquisitions are happening. As we know, India is developing and their GDP is increasing by more than 7% to 8%, and our target by 2047, Modi ji has said that we should be the number 2 economy in the world. So the role of merger acquisition and restructuring becomes very important. And today's speaker, all speakers are very insightful and they all speak very well. And I think they have justified, because their timing was from 10 to 11 and it is going to be 12. Everyone has spoken very, very detailed. So I must say thanks to each and everyone. Pawan Kumar Vijay, starting from Mr. Basudev Mukherjee, he has delivered welcome address. And after that, Mr. Pawan Kumar Vijay, who is the chairman of this ASSOCHAM, this committee, and also chairman and founder of Corporate Professional. He's spoken and discussed various deals, Air India, Piramal, SBI, Energy, and talked about various role of the regulator, Act, Income Tax, SEBI, ROC, RBI, CCI, Competition, CCI Act. And he has pointed one important thing, that in India, while takeover or for merger acquisition, we are not allowed to take loan, whereas everywhere in the world, one can take the loan. So I think that is very important point he has been pointed out. So ASSOCHAM should forward this suggestion to the government, that India is going to be a big economy, so that kind of funding is very much required when you are going to take a merger and acquisition for a big entity. After that, Mr. Ranjit Pandey, former president ICSI and council member, he spoke, talked about FDI in India, clarity required. Various clarity is not there. Talked about uniform stamp duty in various states to be done, NCLT, talking about timing in NCLT, post-merger clearance taking a lot of time. So Mr. Soghaldia is also talking about various issues. He is chairman board of IIP, ICAI, talked about various issues and of NCLT, CCI, and other challenges. And then we welcome and thanks to our special guest Jyoti Dhingar Bhanot, who is Secretary, Independent Charge, CCI, Government of India. She talk about that it required dynamically facilitated smooth, they are facilitating dynamically facilitated smooth and simpler process in approving the transaction in CCI and providing all supportive guidance and all that. So I'm just briefing. You talk a lot of things, and your entire speech giving full detail. So, and our chief guest Sandeep Garg, ED, IBBI. Sir, you talked about so many things: approval of resolution plan, resolve various challenges, code of conduct, various reforms under process, interim finance, which is very much safe, and so many things. And I think Advocate GP Madan, who is my friend also, and co-chairman association, ASSOCHAM Task Force for Corporate Restructuring and M&A, he summarized, which was my role, summarized and given the important insight of every speaker. And very good. I think his energy level was very high. And he also talked about a very important point, draft resolution order. So it can save time of resolution professional and adjudication officer. So I think I am expecting future. So starting, when start is good, so end should also be good. So once again, I am thankful to ASSOCHAM for giving me this opportunity, and thank you very much. Wish you all the best.
Thank you, Subhas Agarwal, sir, for your kind support and delivering the concluding remarks and vote of thanks. Ladies and gentlemen, now we will be moving on to the first session, which is delayed by almost 1 hour. Apologize for that inconvenience, and please adjust to the time. The session will be on new dimensions in M&A regulatory framework. In the meantime, I would request my team to please replace the nameplates. Ladies and gentlemen, now we have the first technical session on new dimensions in M&A regulatory framework, which will cover the legal framework that adheres to M&A takeover and foreign investments. We have the moderator of this session, Mr. Pawan Kumar Vijay. He's the chairman ASSOCHAM Task Force on Corporate Restructuring and M&A. We will be joined by Dr. Girish Ahuja. He's the Central Government Nominee Director on Board of State Bank of India. We have with us Ms. Neha Raj, Joint Director Law, Competition Commission of India, Government of India. We have eminent speaker Ms. Raj Rani Bhalla, Partner MB Kini. We have with us Mr. Sameet Gambhir, Vice President Corporate Law and Company Secretary DCM Sri Ram Limited. We have with us Ms. Geetika Anand, Senior Vice President Company Secretary and Compliance Officer of Aditya Birla Fashion and Retail Limited. We have with us Mr. Manoj Kumar, Partner and Head M&A Transaction Corporate Professionals, and Ms. Shruti Agrawal, Director and Head Investment Banking and Corporate Finance, SMC Global Securities Limited. to our special guest in this session, Ms. Neha Raj. She is Joint Director, Competition Commission of India. Bring. Now I hand over the mic to our moderator and chairman of this task force, Mr. Pawan Kumar Vijay sir. Over to you.
Hello. So good morning, friends. Again, we are starting our panel discussion. And this is the first panel discussion and we are already late. So we have to escape certain ritual. Friends, as you are aware that this particular panel, first panel, we are discussing new dimension in M&A regime, regulatory framework. So in this topic, we are discussing what are the trend going on, what the industry is thinking, what the regulator is thinking, and what are the hurdles and how to remove these hurdles. So basically, we will discuss this issue. And today, we have our panelists, Geetika Anand, then we have Rajrani Bhalla, Samit Gambhir, Neha Raj Madam from CCI, then Manoj Kumar, and Shruti Agrawal. So all these people are part and parcel of M&A transaction in their company. And we will discuss and we'll throw points to them. So topic is assigned to all the people, and the main focus will be, Madam will discuss about the competition law and M&A transaction. We will discuss about the new dimension in M&A regulatory that Rajrani Madam will cover. Geetika Anand will discuss about the industry prospects and various other things related to M&A. Manoj will discuss about the regulatory framework for merger and hurdles which we are facing. Samit will discuss effective due diligence when you do M&A transaction, and Shruti will discuss emerging trend in M&A. Because Geetika Anand has to go to catch her flight, so I'm just changing the schedule. So I'll start with Geetika because she has handled so many M&A transactions in Aditya Birla Group. So we will start with you, and you can cover up your part that what are the issues which you have faced and what you want to give the message to all and suggestions to improve this.
Thank you, Mr. Vijay. I think I'm the first one to say a very good afternoon. Congratulations, ASSOCHAM, first of all, for the 9th International Summit, and thank you for having me here. As Mr. Vijay already said, that this is a panel discussion and we have distributed topics amongst ourselves. And as an in-house council, we've handled mergers and acquisitions more so in the last 4 or 5 years than ever before. And therefore, I'm here to share an in-house perspective of how the trends, the opportunities have worked around for us and what the outlook for the future from our perspective. But an important disclaimer before I start. While I've been associated with the Aditya Birla Group for 16 years and my majority of my experience comes from the work that I've done there, whatever I say here is a personal thing and shouldn't be associated to my organization. With that disclaimer, I'd start. I think if I give a very overall perspective of the last 3-4 years and I stand here reflecting along with you when I look back, we belong to, my entity belongs to fashion and retail industry. And it was one of the sectors which got deeply affected more so in COVID. While we were doing transactions also in 2018-19, but the way things have changed, at least for us, in 2020, 2021, is more so from an overall perspective without getting straight away into technical things is the fact that I see a lot of engagement with the regulators. Starting from CCI, where we've seen early engagement before filing the Form 1 or Form 2, and thereafter going through the entire time clause process has eased out the entire approval process for us. I don't think we've, and not just because she's sitting here, but I don't think we've faced any hurdles with any of the regulators if there has been an engagement. So the highlight point, under inverted commas, is active engagement with the regulators. And I think this also comes from the fact that the last 2-3 years have more been about changing and adapting. And one thing that I can also say, I think everyone in the room will echo the fact that the way SEBI has come around in terms of the relaxations, not just from a point of view of the regular compliances, but also in terms of capital raising and transactions. We were a part of 3 capital raising transactions in 1 financial year. And we were happy to be the first ones to get exemptions which were required to reduce time. Like, for example, in rights issue, the companies which had not come out with an IPO did not have to go through a full disclosure. There was an exemption, a first-time exemption that we got. Now, the highlight is not that we got it. The highlight is that the regulator understood that at that point in time, it was the most logical to do so. And I think that is one of the highlights for us, that we have seen a lot of doors opening in terms of active conversations happening. At the same time, well, that's the very strong positive side. The neutral side to it is that we also see a lot of level playing field that has been created for all the stakeholders. I wouldn't necessarily point at proxy voting as well as the proxy advisory firms. But yes, they have been heroes in the last 4 or 5 years. And while it started with a bang, and there has been robo-voting by FIs and FIIs, and I speak that because that is one of the biggest challenges that businesses and organizations face when we put out M&A deals. If I can cite an example of, say, the Hinduja merger, where it was merging with a group company, and there was a very strong opposition and negative voting by the proxy advisors, the shareholders still went ahead and voted. More than 90% of shareholders still voted in favor. The point that I'm trying to make is where we started a few years back with someone just closing their eyes and accepting the votings. I think with all these changes, a bigger change that is happening is that the companies are engaging with its stakeholders, including the major shareholders, something that I have not seen, at least in my own experience about 7-8 years back. More so actively, and that is leading to a lot of good dialogue. And as a company secretary, a very proud company secretary, as I say, when I stand here, I feel a lot better as a professional, because you are not just looking at procedures, but you are actively taking part in strategic decision making as well as structuring of transactions, because if a transaction doesn't suit, if a structure doesn't suit the governance requirements, not just of proxy advisors but of the regulators also, we have seen our structures being discussed with SEBI where they say that let us step back and understand whether this will be looked at as a governance friendly structure by the stakeholders. I don't think we were having these active dialogues in the past. And this, I think, is a very welcome change. It is challenging for the organizations, more importantly, because voting is one of the biggest challenges. But I think as a professional, if I keep aside my work area, I think this is a very welcome change. And there are obviously technical issues that we face when we are structuring these deals. For example, the RBI Press Note 3, which was the talk when COVID had just started, and it was more like a voluntary saving of Indian companies for getting takeovered by the countries which are land bordering. But I think what the industry has been waiting for the last 2 years, if I may say, including us, is a little clarity in that press note. And I think this has been widely covered by the media as well. There are people like ASSOCHAM also talking about it. I think that is one opportunity area that we must say as an industry body, go back and say that we need to understand what is prohibited. Because today, as the press note 3 reads, every investment by a land bordering entity is prohibited, and that may not work in all structuring deals. There are PE investors in many of our businesses who have committed investments that they are supposed to make. But because of this lack of clarity, we are unable to do so. And the time being taken to get this clarity is also a little more than the others. And therefore, that's one big area there where we think that a little clarity would help. I'm going back to SEBI because I think they've played a superly active role in the last 2-3 years in mergers, acquisitions, capital raising. And I would say that in capital raising, while the main object is to raise capital, but I think today as we look at the due diligence process that goes on through for capital raising, even when I talk to my law firm partners who we engage, I think the bigger question that they say is, Ritika, we need to look at governance concerns as well as structuring concerns, but not from a point of view of stopping the deal, but from a point of view of creating a remedy so that we want to structure the deal. And having said so, the experience that I get from them also is the fact that because there is a little, I can say, lack of clarity as to how much time varied regulators will take, the risk-taking ability of industry and organization for structuring an M&A deal has gone down a little lower. They are fine to structure the deal in a way that there are precedences and there will be an easy clearance. Because now as we speak, we at least have about 8 bodies that need to clear a M&A deal in the country. Also, if you're a sectoral industry, then a sectoral regulator added. So having said so, I think I'd again repeat the point that the regulator, especially SEBI and CCI, have come across and have done it so fast, so easily for us, that we are able to put across our point. I don't think even COVID or lack of meeting them physically has derailed the process. It has only worked more in favor of us. Having said so, one of the SEBI amendments that I think all of us were looking forward to and has come about is the whole combination of delisting and open offer. It reduces the time lag by about at least 3 months, if I say procedurally. And majorly, I think it saves a lot of structuring and strategizing challenge. Having said so, I think even as we speak, there have been months since that law has passed. However, still there is not even a single company who's utilized that process. I think one of the reasons being, and that's an opportunity area, or maybe a feedback area, is that the pricing has not been capped. And I think the promoters who do want to delist in that process do want a understanding on that pricing. If I want to continue pricing as a thread and also, stitch it to the other capital raising formats, which is preferential allotment and the others, I think one of the biggest things that we see is that the market is so volatile that if I go and price my stock by the 26-week average method, I still end up getting a very haywire price. I think 90-10 WAP, I don't want to get very technical, but the 90-10 rule works the best. And I think that's also one of our active submissions and feedback to SEBI, that if that can be adopted, especially at a time where the stock market is very volatile, because then it helps us and the investor who's investing in to come with a little deeper feet into the entity. I think other than that, I covered governance, I covered risk-taking, SEBI and RBI Press Note 3, and I think other than that, if I have to overall say, the fact that the industry has been able to quickly adapt to COVID times and be able to raise capital, and I can speak for us as well as the other companies, the way we have been able to raise capital, I think that has been extraordinary well. What I do want is that this should not just be an outcome of COVID. This should stay on. And the active engagement should stay on irrespective of the fact that time requires it or not, because this has proved to be a boon for all of us, a blessing for all of us. Thank you.
Thank you. Thank you, Geetika, for starting this. As you are aware that SEBI is no doubt a very proactive regulator, and for M&A transaction, the main issues comes from SEBI side, because they do thorough checking, and the role of proxy advisory is also very, very active now. And whatever transaction you are doing, they have a eagle's eye on this, and they take care of this part. And now it is happening that people have started taking proxy advisories perspective also when they draft the scheme. Thank you.
Sorry, can I mention one more point? A point that I forgot to add, I'm sorry, is the fact that we have certain entities which are also listed with US SEC. A very big difference that we saw over the years between US SEC and Indian regulators was the fact that if we would apply for something there, it was kept confidential for months together until the company would sign up and say that now I'm ready to put it publicly out there. While it may still be here, we were not that confident. I think that is one big stark change that I've seen in the last 2-3 years with the regulators. CCI obviously has a confidentiality agreement. But even with the other regulators, when we have discussed structures informally with them, they have stayed watertight. And I think that gives a lot of confidence to the company's management to be able to openly go and discuss structures without the lawyers and investment bankers. So confidentiality is a welcome change.
Yeah, confidential issue is also there in India, and it has to come out something new shortly. They are discussing it. Yes. So, friends, now our next panelist, Ms. Neha, she's from CCI, Competition Commission of India, and she will discuss about the aspects of merger relating to CCI prospects. So, madam, you can speak. Yeah. Other panelists can decide. After that, you can speak from here also. So, okay.
I'll have to excuse myself. I'm so sorry.
No, thank you.
Thank you, everyone. I'm sorry I have to leave.
Thank you, Shri Pawan Kumarji. Distinguished panelists, participants from legal fraternity and industry, very good afternoon to you all. Before I begin, I would like to thank ASSOCHAM for inviting me to be a part of this panel, and I appreciate the opportunity to participate and speak with you all. Conferences like these are a gathering place of ideas and of people. Gatherings like these are how ideas get exchanged, issues get discussed, and awareness gets created. And this is why this is the right place to talk about the importance of competition, the role of CCI in enabling competition and sharing ideas about new dimensions in merger control. Now, competition is one of the most important cornerstones for the growth of the economy. It benefits people through lower prices, more choice, higher quality for consumers, stronger businesses that are incentivized to perform and innovate, and giving businesses a fair chance to compete domestically as well as internationally. Now, there are several challenges today in today's world. A long global pandemic, wars in Ukraine, inflation, all of these have consequences for our economy. Thus, a growing need is felt for discussing the role of competition in our economic health. In context of competition law, given the growing significance of the digital marketplace in the current economic scenario, most of the discussion is centered around the need to modernize the law for digital marketplace. While some want to maintain the status quo on competition, others say it's well past the time for changes. At CCI, we have always been nimble to the needs of the economy and the changing business environment. An important conversation taking shape around the role of competition law in the Indian economy is occurring against a backdrop of increasing concerns about the rise of large digital firms and the changing nature of our digital marketplace. Regulators, industry, and other stakeholders have engaged in debate on novel issues and the challenges faced. With a rise in concerns about the conduct of large digital firms and their impact on markets, the questions that have gained importance are whether, and if so, how these markets should be regulated. It is hotly debated whether mergers in digital markets can be assessed effectively in current framework, or digital markets are a new landscape that require an adjustment. In this context, one of the aspects that is highlighted in large number of acquisitions in the digital marketplace is that the acquisitions are not only reducing the potential competition in the market, but also resulting in increased concentration in the digital markets and harming the incentives to innovate. So today, competition matters more than ever. Globally, there is a shift towards more aggressive enforcement of competition laws. This includes proposal to review and revamp the existing competition laws. Governments around the world are looking for new policies that put competition at heart of the economic recovery and growth, particularly digital markets. In many ways, merger review is the first line of defense in protecting competition in the economy. While only a small number of mergers raise competition concerns, those that do can cause significant harm to consumers and the economy. In these cases, timely and effective action is required to protect public interest, as the consequences of increased concentration can get reflected across diverse sectors of the economy in form of higher prices and lower quality. Over the years, CCI has endeavored to achieve the right balance through efficient scrutiny of cases, ensuring procedural fairness, and making calibrated interventions keeping in mind the nature of the transaction, the sector involved, and the overall state of the economy, so that companies can effectively benefit from the mergers and acquisitions. But at the same time, they do not undermine the overall functioning of the markets. While evaluating harm to competition in terms of price and non-price effects, other aspects such as efficiency gains, new products and processes, and new competition that mergers and acquisitions can bring about are not lost sight of. It goes without saying that mergers and acquisitions are crucial instruments for investment flows, creating economic synergies and contributing to the processes of economic development. CCI endeavors to act as a facilitator in this process through efficient and expeditious assessment of combination filings. Starting from 2011, we have received approximately 970 notifications across varied sectors, including over 60 green channel notifications. In more than 950 combinations reviewed so far, remedies have been ordered only in few cases, around 20-odd cases. As part of ongoing efforts to reduce compliance burden and promote ease of doing business, in 2019, the Green Channel system for automatic approval of combinations was introduced. The Green Channel system, as mentioned earlier in these sessions, is a first-of-its-kind trust-based system for facilitating speedy disposal of cases by giving deemed approval on the day of filing notice itself for certain transactions that specify the criteria given under the regulations. CCI has also been taking other measures for procedural simplification, speedy disposal, and reducing compliance burden on combination filings. Keeping in focus stakeholder concerns, the combination regulations that came into effect in 2011 have been amended from time to time. For instance, in 2018, a provision was introduced to allow parties to offer voluntary remedies in response to prima facie concerns of the Commission. The provision gives flexibility to the parties to propose remedies and helps in timely approvals of cases where investigations could have otherwise taken a long time. Parties are also allowed to withdraw and refile their notices to the Commission without incurring additional costs. Recently, in March 2022, CCI has amended the Form 2, that is long form for merger notification, to limit information requirement to only focused and relevant information. This amendment is a part of series of measures taken earlier by the CCI towards simplification, like amendment of short form, that is Form 1, and issuing guidance notes. CCI is also mindful of the fact that the measures aimed at procedural simplification do not undermine the mandate of the Competition Act in respect of merger control. Under the Act, CCI is required to make a regulatory intervention ex ante with respect to those transactions that meet the criteria prescribed. The merger control provisions in competition law aim to ensure that no transaction which is likely to cause an appreciable adverse effect on competition is in a relevant market is permitted, unless adequate modifications can be put in place which could significantly mitigate the anti-competitive effect that the transaction could bring. Not only in India, but world over, merger provisions enable competition authorities to examine and assess corporate transactions from the standpoint of whether transactions are likely to harm competition in a given market. In context of mergers in digital marketplace, CCI, like competition authorities globally, also faces the question whether Indian Competition Act is well equipped to deal with mergers in the digital markets. For this, a brief look at the preamble of the Act would show that the scope of the Act is broad enough. The list of factors provided under subsection 4 of section 20 of the Act determine whether a combination would have the effect or is likely to have AEC in relevant market include a number of factors like level of market concentration, entry-exit barriers, degree and nature of vertical integration, countervailing power, nature and extent of innovation, availability of substitutes, etc. These factors enable assessment of combination, including those of the digital sector. The assessment in these markets too entail understanding the market position of merging entities, competitive interaction between them, formulating theories of harm, and assessing competitive effects in horizontal, vertical, or complementary levels, weighing the likely anti-competitive harm. However, merger control in digital market also poses some unique challenges. Digital markets are dynamic in nature and characterized by various factors such as proliferation of data, network effects, switching costs, etc., unlike the traditional markets. These factors may lead to a situation where the market is concentrated but with very few firms remaining. Thus, the assessment for AEC is more challenging. For instance, Commission may face challenge while defining the relevant market. Delineation of relevant markets requires taking into account market realities that exist in a certain point of time. Now, the exercise of market definition and determination of market power has to reflect the rapid evolution in technology markets and high pace of innovation. The relevant market definition adopted, say 2 years back, may not necessarily work today. In such scenario, market assessment cannot be a static approach. Another key challenge is coming out with a theory of harm. In digital markets, the focus cannot be on price effects alone, as price is often a non-significant factor in competition in many digital markets. Factors such as data quality, choice, and innovation that shape digital competition landscape may be more relevant for formulating the theories of harm. Similarly, in cases of acquisition of nascent firms, a major challenge can be formulation of a relevant counterfactual. It may be difficult to assess at time of examining a proposed acquisition whether acquired firm could grow into an effective competitor absent the merger. The evidence gathering exercise may thus have to focus on the likely trajectory of the growth of the products of acquirer as well as the target, which itself is challenging. Now, there could be data-driven acquisitions also, which may lead to concentration of data or give rise to issue of market power on account of data synergies. In such cases, challenges to determine whether the data sets that are being integrated are unique and cannot be replicated. Most firms in digital markets possess vast amounts of data and the capability to process it with artificial intelligence and machine learning algorithms. The acquisition of companies that possess any kind of data by big technology firm may result in an advantage for the latter, which cannot be replicated by the new entrants in the market. In case of platform markets, issue of differential pricing and even to an extent zero pricing may be adopted in order to maximize overall profit. Further vertical relationship may raise issues of preferential treatment. But the merger cases in digital markets reviewed by the Commission have not been many. Our case experience in the review of digital mergers is rather limited. One reason for this could also be that all combinations related to the digital sector may not be notifiable to CCI. Not only the notification threshold in the Act is high, but the combination where enterprises whose control, share, voting rights, or assets are being acquired, or have assets not more than 350 crore in India, or turnover of not more than INR 1,000 crore in India, are exempt from notification under Section 5. While digital space in India has witnessed a number of transactions in e-commerce, ride-hailing, online food delivery, etc., there is no readily available comprehensive data set on digital mergers in India to assess the number of filings that might have escaped the scrutiny of Competition Commission. In 2018, the government had constituted a competition law review committee, which also evaluated the adequacy of legal architecture in dealing with new age markets and big data. CLRC found merit in exploring possibility of setting out other clear and objective quantifiable data for notification, which catches not only those transactions that have significant economic link to India, and neither the CCI nor parties are burdened with unnecessary notifications. An outcome of this is seen in the recent Competition Amendment Bill, wherein DL value threshold has been introduced. In last couple of years, the digital space in India has witnessed a lot of transactions in the digital space. As per data with the Commission, compared to 2021, only approximately 9% of the filings related to e-commerce and IT sector. In 21-22, almost 17% of our filings were received in this sector, which shows that post-pandemic, online market has become more entrenched in India as well. Market position of international as well as domestic online players has strengthened, and various offline players have entered into the online segment. Some of the cases which have been assessed by the Commission had been mentioned earlier also include acquisition by Jio in Facebook, acquisition in Jio by Facebook, acquisition in Jio by Google, acquisition in Bharti Airtel by Google, acquisition in Ola by Hyundai Motor, acquisition in ABFRL by Flipkart, acquisition in Baiju, and then acquisition Big Basket Tata Digital, and so on. The current merger assessment we find are at the CCI that our tools are largely relevant and fit to assess transactions being notified in digital markets. The legal framework set out in the Act for determination of anti-competitive effect is broad and gives us flexibility to assess and develop theories of harm that may be relevant in digital markets. Although digital markets bring in new dimensions in assessment, we tread cautiously so that speculative theories do not replace objective and evidence-based analysis, and our interventions in merger cases continue to be guided by case-specific economic evidence of competition concerns even in digital markets. Before I conclude, I would like to say that our goal is to achieve right balance between market realities and competition regulation. The objective of the Act and the Commission is to ensure healthy competitive environment based on trust and communication in harmony with the evolving business environment. To make a trust-based regime sustainable, it is imperative that businesses adopt a proactive compliance culture in their corporate governance structure. Needless to say, the Indian economy is evolving, and so will have to our approach to keep the markets, including digital markets, competitive in interest of both businesses and consumers. I appreciate that today's conference is an attempt to bring all stakeholders together for an exchange of views and constructive dialogue on the new dimensions in the merger and acquisitions regulatory framework. Such events allow regulators, stakeholders, and practitioners to brainstorm emerging issues and evolve approaches for identifying and addressing concerns. This is why events such as this are important. With this, I would like to thank ASSOCHAM again for inviting me to be a part of the panel and share experiences with you all. Looking forward to an interactive session. Thank you.
Thank you, madam. Thank you very much for giving a right perspective of CCI and giving the what CCI do and what are the challenges you are facing in digital world. Now, I will request Rajrani madam, because she was ex-SEBI and she is in practice of a listed and unlisted company, and she has handled so many mergers cases. Madam, please tell us the new dimension in M&A regulatory prospects. What you think and what are the changes? Because you have seen working in SEBI and now the market which is taking place.
Thank you, Bhavan. Good afternoon, everybody. So before I start with the topic, I would like to just say a few words about my firm. I am partner with MV Kini. Firm was established in 1978, and today it has 24 offices across India. Pardon me for, I'll just take 2 minutes.
Madam,
1 minute for this.
This
okay.
we are avoiding.
Just 1 minute.
We are not communicating. This is not.
No?
Yeah.
Okay, I'll skip this then.
Because time
It's
is
there.
also short. So.
It's there. It's there in our PPT if somebody wants to look at it, okay? So now I would like to give a bird's eye view on the framework and recent developments for M&As in India. Like to all experts, know that M&As are regulated by various statutes, and everybody has said it in the past here. Companies Act 2013, Competition Act, IBC Code, and I would like to mention FEMA and IT here, because which people have not mentioned. FEMA does not per se talk of mergers and amalgamations, but by regulating capital inflows and outflows into and from the country, it kind of comes into the scenario where there is a cross-border merger and amalgamation. Also, Income Tax Act gives certain benefits to amalgamating as well as amalgamated companies. And securities laws has also been covered by various speakers in the past, so I will not take more time. Time is short before me. I'll talk about the regulatory changes that are likely to have an impact on M&A transactions in India. One is increase in FDI limits. So in insurance and defense sector, we all know that it has been increased from 49% to 74%. And in other sectors also, like telecom, petroleum, natural gas, petroleum refining, FDI thresholds have been increased to 100%. Of course, subject to compliance with certain sector-specific conditions. And we heard Gitika talking about the PN3. So that PN3, which was issued by RBI, certain changes have been made in the Companies Act also, the rules there too. Now a declaration has to be given. Declaration has to be given by subscribers and first directors of a company being incorporated to specify whether approval of the government is required in terms of PN3 prior to the subscription to shares itself. And also whether the person seeking appointment as a director is a national of a country that shares a land border with India. Because PN3 talks of the investment coming into India from the landlocked border sharing countries, that it is all to be approved by government. So now they have to, at the first level itself, they have to come and give this declaration. And, and this will also apply to the cross-border mergers and amalgamations and demergers as well. So another development is that MCA has permitted startups to adopt fast-track mergers without obtaining NCLT approval. Only a notice of the proposed scheme is to be sent to the ROC and the OL, inviting objections if any, and which they have to give within 30 days. Otherwise, they can just go ahead. So this is another very good change. SEBI also, though people did speak about SEBI, but this is an amendment which permits the acquirers to make a combined offer for delisting the shares of a listed target company while making an open offer. Gitika did touch upon it, and I think the problem they were facing, they can always, because I'm an ex-SEBI, my loyalty still lies with them, so they can seek informal guidance. I was telling her that they can seek informal guidance from SEBI on this aspect, if there is still some doubts about it. So like as we have the regulations, of course, there will be certain hurdles also. And hurdles would base whether the company is a public or a private, listed or unlisted, resident or non-resident. One example of such difference is application of pricing guidelines. If that is the method of determining the price at which securities of an Indian company can be issued to a non-resident or transferred from a resident to non-resident. So you have to apply the pricing guidelines. Then there are sector-specific hurdles, like if it's a company which is regulated, it's an insurance company and is regulated by IRDA, then of course they have to comply with the regulations and the whatever directives their regulator has given. Now we come to the interesting part. Of course, I was thinking it is clashing with my co-panelist, Samit. Little bit I would like to speak about due diligence, because I believe we are very good at due diligence. So why do we need a due diligence in an M&A transaction? Question is, why do we need it? So one is that inherent bias. See, both sides want to, the seller would like to give his best optimistic assumptions, and the buyer would like to have a kind of a verification whether he could go with that kind of assumption which the seller is now giving. Then of course there are inaccurate financial information. It may be inaccurate, it may be incomplete, it may be misleading. So you need due diligence again. Then, of course, the risk analysis comes, and I'm sure Samit will talk in more details. And it helps in benefits in the negotiation. We lawyers also handle both the parties, and we try and bring them to strike a deal. And why the importance it gets is because there's an inability to seek restitution. Once it is done, there's nobody else to blame for your mistake if you've done before buying. Like it said, buyer beware. You have to, before you're getting into the deal, you have to know what all are the risks involved. So, and how to do nicely? Well, financial experts cover the financial aspects, and legal due diligence is done by the professionals like us, lawyers. And I will not go into much detail, of course, but we just do the background checks of all the entities involved, all the promoters, directors, company, associate company. We go to various court websites, we go to Watch Out Investor website, we go to CIBIL. We do all that, and we also check into the material contracts if they have, whether there is any onerous obligations on the company which the investor might be hurt and stuck with. And for regulatory compliances, we look at which sector the company is, whether it is manufacturing or whether it is a service company, because it would depend. The regulatory compliances will depend accordingly. And some regulatory compliances are due to the location of the company, because various states have various laws. So I'll just stop myself on, though I could go on due diligence for very long, but I have indication that I have limited time. And on the listed companies, again, I'm skipping this slide though, because Manoj would be, my co-panelist would be speaking about it. I'll just touch base little bit on this HR issues and strategies. So in that, integration managers are being appointed these days, or they may call themselves as transaction advisors. And they address pre- and post-merger concerns. The HR leadership of both organizations, they try to achieve the synergies in the best possible manner. But there may be some labor issues in the cross-border transactions. So if it is a local, both the companies are local, then the workers who are displaced, because there is a synergy, now you don't want all that workforce to stay with you. So you would like to displace some. So some of the SPAs they do say that, well, you will have to maintain this workforce for at least 1 year. But it is difficult for cross-border transactions. How will they find a job in another country? It's an alien country. And
ILO recommendation come into picture in cross-border M&As or in domestic M&As?
ILO I have not touched upon. Asta, can you read that from there?
No issue, we can discuss later.
Yeah, let's discuss. Don't ask embarrassing questions. You wanted me to say, I don't know about it. I'm rushing through it. I have got very little time. And then the corporate governance considerations are there, and the role of independent directors becomes very important, because they have to take care of the stakeholders' interests, that is the promoters, as well as the minority shareholders. So while having this kind of deal, they may even appoint their own set of advisors, different from those appointed by the company, because they have to have a neutral role. Then it is risk management for cross-border acquisitions. Acquirer will not be subject only to an alien regime, but also to a different culture. So companies acquiring overseas targets are presented with unique issues and unusual compliance risks, because they do not know exactly, and they have to really do a thorough investigation before that. So having discussed about all these labor issues in cross-border transactions, now I would like to speak about those little bit more about it. Like, we see that, like in certain states, even in India, there are different laws and regimes, as I said earlier. But if it is across borders, then like was it Burger King or which burger manufacturing, McDonald's, somebody had a difficulty regarding beef being used, and other countries they use. So like you have to, when you are synergizing the two companies, you got to know what is permitted and what is not permitted. And like our wage code has now been improved, I mean, with the consolidation, there are certain, but there are other countries where they may take much longer time to remove a worker from, I mean, you can't just hire and fire. So you have to have that kind of study of both the domestic as well as where the target company is located. Then there are, of course, as I was saying, soliciting business by lawyers in India is not permitted, whereas in other countries it. So if the two law firms were to merge, we have to consider what is allowed and what is not allowed. So having dealt with most of the issues of the concerns with M&As, I think I will like to take, I'll give the mic to somebody else who will elaborate on their respective topics. Thank you so much for listening to me patiently.
Thank you, madam. Thank you. I'm just rushing because time is short. Yeah, thank you. Thank you very much. Okay. Now, she has talked about the various aspects of M&A. Now, whenever we are doing M&A, there are some hurdles. And we must understand what are the hurdles and how to overcome this. So I'll request Manoj to discuss the M&A hurdles and how to overcome this.
Good afternoon, everyone. So I think many of the things have already been discussed in detail by Madan sir in the first session and various other speakers. So I am, in case there are two types, if we are talking about M&A transactions, there can be two types of transaction. One is private transaction, which is basically acquisitions or takeovers of company. It may be private or a listed entity. For that, there is a limited regulatory interventions, except like CCI or sometimes FMI issues may come. But when we are talking about mergers and demergers, which is a court-driven process, which is NCLT regulated process, there are two major regulators. Okay. There are two major regulators. One is MCA-related entities like ROC, RD, and ultimately the adjudication authority, that is NCLT. But before that, if it is a listed company, SEBI is one of the key regulator which has started intervening in last 7 years very actively in all M&A transactions. So if we see the transaction involving listed entities, there are certain specific additional obligations on the companies. One of the very important obligations is relating to valuations. So if we are talking about the valuation, they have maintained that all the valuation need to be done based on latest financial, which is not more than 3 months old. So that is one of the area where all the valuer need to take care of the same. Then additionally, they want that the valuation of listed entities share must not be less than the preferential allotment pricing guidelines, which is volume weighted average market price of 10 days and 10 trading days and 90 trading days, whichever is higher. So that should be the minimum value. Besides that, they have also put the requirement of having fairness opinion by a registered SEBI registered merchant banker over and above the valuation of registered valuer. So these are the valuation aspect. Then this valuation need to be recommended by the audit committee of the company, listed company, and then only it can be placed before the shareholder board of directors of the company. The another aspect is if the scheme involves unlisted company, then there is a requirement of due diligence of that listed company, unlisted company, and that due diligence must be certified by a SEBI registered category 1 merchant banker. So these are the governance aspect as well as protection of the interest of the public category shareholder. Then recently they have also made a requirement that the scheme must be also vetted by independent directors committee. So that is to protect the interest of the public category shareholders, and they give their recommendation to the company, and that is filed with the stock exchanges while they vet the scheme. So this is one of the part. The one very critical and difficult aspect of SEBI regulations is that they want the public holding of listed companies should not go below 25%. And in 2018, they have made it mandatory that on fully diluted basis at the first instance, the holding of the public should not go below 25%. So many of the time it becomes very difficult to make a swap ratio which is adjusted, which is not going beyond 25%, 75%, because if the existing promoter holding is substantial, let's say 51%, then it is very difficult to adjust everyone else, new shareholders of the unlisted company within that 25% limit. So that is one of the biggest challenge. Then if we talk about the other challenges which is being faced right now, as Madan sir was also discussing, there are various regulators which give their no objections at the time of approval by the NCLT, and we have found that there is different practices among the various regulators of like RD of North and South are not acting in the same manner. Similarly, different benches of NCLT are also taking a lot of different kind of views on same issues. So the uniformity is one of the key issue. Then timelines is also one of the very critical aspect because M&A is very critical and very important for inorganic growth of the organization. But we see that in NCLTs, benches are limited and there are vacancies due to which, and the priority is given to IBC cases, which is also very important, but M&A transactions are not getting so much attention and hence timeline gets dragged. I think yesterday itself, MCA has notified and extended the limit of the small company to 4 crore in paid-up capital and 40 crore in net worth turnover. I think this will reduce a lot of burden of the NCLTs. Many of the companies could go on the fast-track mode. So MCA and regulators are very responsive, but still there are hurdles which is creating a lot of problems. So I think these are the major things. And we can, I think, because the time is short, I'm not going in detail on all these aspects. Thank you very much. We can discuss it further.
Thank you, Manoj, for adhering the time. As you are aware, that there was a comment that NCLT formed for making the time limit to do the work faster. But now somebody is saying that NCLT taking more time than the court. And the court was the better place. So that is one aspect. I hope what Madan has informed that more NCLT members are coming, it will solve. Okay, now we have heard about the regulatory aspects, hurdles. But when you do M&A transaction, the most important thing is the due diligence. And what are the issues in due diligence? What practical aspects we should see? Because Smith has done various transactions on M&A, and he was a part of the company side. So he has part of all negotiation, all discussion, all SHA. So I'll request Samit to discuss about the practical aspects of M&A when we do due diligence, when we do M&A transaction.
Sure. Thank you very much, Pawanji. I think it's the only option for me is to share the practical because everything is covered by Madam already. Okay. Okay. That's my favorite subject, by the way, due diligence. So I think there are a couple of things which are very, very important. We normally do a legal due diligence. That's very important, and everyone understands that legal due diligence is must. And we, normally what we look into the litigation, the potential risk, and, if there are litigation which has been settled in the past, recent past, whether there is any liability can come. So, we all understand that the legal due diligence is very, very important, and we always take care of that very seriously. But what we don't do seriously is something, which I've seen in practical experiences are very, very important issues. Financial due diligence, we always see that if there is any contingent liability in the books, or if there is anything, accrual is wrongly done, or, some accounting issues, etc. One of the important issue, we were discussing in cross-border merger, one of the cross-border merger where, we were acquiring something. And in one case, we thought, we should do some more intelligence rather than the legal due diligence or financial due diligence. We started to do some more intelligence. And, in one of the case, there was, when we were doing a lot of due diligences, a lot of other things, so there was an amount of inventory lying in the godown of that particular company. And it was a pandemic time, so we were not able to actually verify the inventory, but, there was a pricing to that, and there was a certification to that, and they got a photograph done for that inventory, for example. And I think, Pawanji ko shayad yaad nahi hoga, because we hired his firm also for that special due diligence. Because he suggested that, we should be able to, I have got certain contacts in that country, and we should be able to do it physically verified. And you will not believe it, when we got it physically verified, all the inventory was rotten. There was nothing in that, and we were able to save few crores in negotiation because of that inventory matter. So, sometimes we really have to see that, we're not able to rely on the certifications, we're not able to rely on the pictures, And in, pandemic, they must have thought that we'll not be able to do a physical verification, but thanks to some consultants that they are able to do it. Similarly, in one of the issue, I was told that, we were doing, it was, again, an acquisition, but a very, very important acquisition wherein a lot of stake was involved in that. So we hired a risk management company, investigative type agency, to do some more investigation because, we have recently seen that there have been some issues in terms of investigation and all. So what that guy told us is that, yaar, aap ek kaam aur karo, and with due respect to all the senior officials here, he says, aap ek kaam aur karo, with my suggestion, just do a reputation check of the CEO and CFO of the company. And that's something we said, no, yaar, we can't do that. No, he said, you should do it. We'll do a covert check. And believe me, we were shocked to see the CFO was on the roll of that company. He was getting compensated by that company. Yaar, main tere ko itna de raha hu, you get this merger done immediately and all. And this was, he got it with proofs. I mean, some techniques they have, I don't know, the investigative techniques and all. They got some proofs, some got some recording, etc. And this was a shocking experience for all of us. So I think, couple of things we really forget in M&A, which really have a lot of repercussion later on. Contracts, we don't generally take, the customers. Is there any concentration on the customer? Do you have one single or two customers which has a lot of, the only 80%, 90% of the sale is going to them? What happens if he goes away? Are you taking a lot of risk in that? So customers, employees issues, if there are employees issues, in a lot of countries there are POSH issues. POSH issues are very, very major issues nowadays. Because if the already there, they are in process, then one has to be very clear that whether it is settled properly, not settled properly. And if, as I told you, if there are issues which have been settled recently, we must be very, very careful that the liability is coming or not. Closing of merger, as we say, that if there are any condition precedents, we have to be very careful that these have been completed or not. So I think cultural issue, for example, we have really seen merger failing or merger, getting failed because the cultural mismatch was there, culture issues were not there. Due diligence की वजह से तो हमने बहुत merger देखे हैं जो finally, they called off actually. So these are some of the practical issues other than legal issues, legal due diligence and financial due diligence, which are absolutely important. I would suggest, some kind of forensic accounting, investigative techniques and all are also required whenever the high stakes are involved in that. So I think I'll finish here because, I know the time is very less here, but these are some of my, practical experience which I wanted to share with you. Thank you.
Thank you, Sumit. Thank you very much. Very crisp. And most important, you have given mic to me. Otherwise, I was indicating that when I'm taking mics, so other people can realize that my time is over. Okay. So you have solved my problem. Okay. So friends, now we have seen this, that regulatory aspects, hurdle, due diligence issues. But why the mergers are becoming so popular, where the trend is going right, and what are the trend which is taking place and what is the future. So I'll request Shruti Agrawal. She's a chartered accountant and she's in part of the SMC. Request to give her view.
A very good afternoon, everyone. Ladies and gentlemen and esteemed guests, I'm truly humble and deeply grateful to ASSOCHAM to invite me as a speaker in this seminar. I'm excited to discuss what we are seeing as the emerging trends in the mergers and acquisition space. Despite the major geopolitical and financial headwinds we are seeing today, Indian M&A market has remained resilient and has seen significant activity this year. In fact, in the first half of this year, the M&A deals have reached an all-time high of 175 deals with a value of $130 billion, which is 30% up year on year. What is interesting to note is last year, in all the M&A transactions, the first-time buyer represented 80% of M&A activity. The first-time buyers were mainly the cash-flooded startups going for acquisitions for speedy inorganic growth. These startups saw acquisitions as a way of getting ahead quickly, building scale, entering new markets, and deliver an omni-channel presence and experience to their customers. These serial acquirers were mainly seen in the e-commerce sector, fintech, and edtech sectors. To give an example, in the e-commerce sector, Thrasio-style startups such as Mensa brand, Global Bees, they acquired around 42 startups. Another example is that in the edtech sector of Byju's, Byju's spent $2.5 billion on acquisitions such as, Akash Institute, White Hat Junior, and others. This trend actually gives an opportunity to smaller players, which essentially means that they have new options for exit, funding, and growth perspective. Another emerging theme that the Indian M&A space is seeing is that the companies are reshaping their portfolio using mergers and acquisitions. So the big Indian conglomerates have realized that a significant portion of their businesses is in lower multiple industry, and therefore it is eroding shareholder value. So what they are now doing is reshaping their portfolios. Companies are liquidating non-core assets and in turn using that cash to buy more core assets and consolidate and capture larger share of pie to build dominance in their particular sector. Some key examples that we have seen is the Mahindra Group, which exited loss-making businesses through multiple divestments. Another example we saw is Tata Group. Tata Group wanted to consolidate its position in the consumer goods segment, and it built its super app, and for that it did 21 deals in last 2 years. Due to the digitization happening in India, which is further accelerated in the COVID era, there is a pressing need for companies to adopt technology. The companies are continuing to invest in technology and building tech capabilities through M&A. The deals in M&A that are happening are not now just to grow, but how companies, as a way of companies to transform themselves. The tech sector saw most number of M&A deals in the first half of this year, totaling up to $16.5 billion, which is up 78% year on year. Another trend that we are seeing in the M&A space is the outbound M&A activity. The companies, Indian companies, are looking to expand overseas to foray into new markets, expand their portfolio, and acquire complementary business capabilities. The outbound M&A this year, in the first half, is totaled up to $6 billion, which is 74% increase year on year. A major outbound deal that happened this year was the $3.3 billion acquisition of US-based biosimilar business of Viatris by Biocon India. This was the largest ever Indian outbound acquisition in the US healthcare space. Another example of an outbound M&A deal we saw this year was India's Lenskart acquiring majority stake in Japan's Owndays, creating Asia's biggest online retailer in eyewear. The surge in investment is also attributable to the policies of the Indian government. Policies such as productivity-linked incentive, Atma Bharat movement, allowance of FDI in some sectors, and others. Further, based on our discussions with investors across PEs and corporates, we are noticing a very key shift in the investment strategy across the board. Investors are now focusing on companies not just who are growing in revenue, have good revenue growth, but are also profitable and are backed by good corporate governance. This is in contrast with the last 2-3 years, where new age businesses with fast top line traffic growth attracted unprecedented investor interest. The shift is partly driven by the macroeconomic factors such as inflation-driven demand slowdown and geopolitical tensions such as the Ukraine war. While this may lead to a temporary slowdown in M&A activities, as investors are taking out time to rethink, realign their investment hypothesis, but considering the agility, resourcefulness of Indian entrepreneurs, the strong fundamentals of the Indian economy, strong intent from the government to support the ecosystem, and the bullish outlook of the investors on the Indian growth story, the good times will continue in the long term. Thank you everyone for being so patient.
Thank you very much. So friends, I think all our panelists has given their viewpoint, and they have given a lot of agenda for the second session to discuss. And I will request Akhil to please come and give the plan to Madam Neha. Okay, sorry, okay, no problem. Okay, so Santosh, you can.
Thank you very much, all the panelists, Pawan Vijay sir, for taking over this session nicely, the discussion that took place. We will be moving on to another session, session 2 on M&A industry trends and outlook expectations for the remainder of 22-23 and beyond. So thank you very much for having you here in the first technical session. Thank you so much. Now, may I request my team to please be ready for making the arrangement for the next session.
Thank you.
Thank you all. So, ladies and gentlemen, moving towards panel 2, we have the session moderator, Advocate GP Madan, Co-Chairman, ASSOCHAM Task Force for Corporate Restructuring M&A, and Managing Partner, Madan Law Offices. We have eminent guest, special guest, we have Mr. V. Sri Raj, Joint Director Law, Competition Commission of India, Government of India. For sharing the industry perspectives, we have Dr. Akhil Prasad, Director, Country Council India and Company Secretary, Boeing India. Ms. Shweta Bharti, Senior Partner, Hammurabi and Sullivan Partners. We have with us Mr. Kunal Mehra, Partner, DSK Legal. We have with us Ms. Ranjana Rai Gawai, Founder and Managing Partner, RRG and Associates. And Dr. Sanjeev Gemawat, Group General Counsel, Vedanta, will join virtually. May I request GP Madan sir and all eminent panelists of this session to please come on the dais. Now, I may request and hand over the mic to Advocate GP Madan sir to take over the session.
Thank you, Santosh. Now, all the panelists are receiving, and 1 o'clock we had to start our lunch, but at 1:10 we are starting the session. But friends, I'll not let you wait for...
Madan sir, I am sorry, apologize for the interruption. May I request my team to please come with a welcome plant. May I request Madan sir to
through
please
my hands only to everybody.
to V. Sri Raj sir. Please.
I'll do the honor. I'll do the honor on behalf of all of you. Okay. What's the time now? 1:10? 1:10. I'll assure you that I'll try to finish it off within the next 40 minutes only. I'll not take 1 hour. And you know, in TV में भी हम सब की आदत है, हम जब पैनल संजीव गेमावत जी वर्चुअल है, ठीक है संजीव जी आपको 4 मिनट मिलेंगे बाकी सबको 5 दे रहा हूँ, मैं आपको सिर्फ 1 मिनट एक्स्ट्रा कम मिलेगा क्योंकि आप वर्चुअल ज्वाइन कर रहे हो. आपने टाइम बचाया भी है ना बहुत. 3 minutes? अच्छा, he says I'll finish up in 3 minutes. Okay. Friends, in the TV also we see the panel discussion for half an hour, उसमें 10 मिनट एडवर्टीजमेंट के निकल जाते हैं, तो 20 मिनट में पैनल डिस्कशन कंप्लीट हो जाता है प्रैक्टिकली वर्चुअली देखें तो. And as I said in my inaugural session also that we need only one amendment and the whole bad impact of this, the recent judgment of Supreme Court in Rainbow Paper can be done away with. तो similarly अगर हम अपनी बात कहना चाहें तो 3 से 4 मिनट में अपनी बात कह सकते हैं. This is my message to all my co-panelists also. Okay. First of all, I'll start with Mr. V. Shiriraj, Joint Director from Competition Commission of India. And he'll be speaking on competition concerns in the digital landscape in M&A. Sir, your job is very tough because some of your issues have already been taken care of by Ms. Neha Raj in the first session and in the inaugural session also. Your secretary also spoke about that. So over to you. I'll just... Yeah, okay.
Good afternoon to all of you. So, as he rightly pointed out, some of the aspects which I have to cover has been, covered by Neha as well as our secretary. Let me share the experience that I had in the last 10 years in the commission while dealing with combinations in digital sector. Friends, almost all the markets that we face today is getting digitized. The way the business is being done is getting changed. The way we have bought the goods 10 years back is not the way we are buying things today. And the significance of M&A in an open market system, I need not say much about it. So suboptimal interventions by regulators is never preferred. It's neither good for the economy, nor good for the business, nor good for the consumers. So the first priority of any regulator is to have a regulatory framework that facilitates deal that is nothing to do with the purpose of regulation. For instance, the competition regime exists to ensure that a merger does not result in a super dominant entity which can dictate prices or the market outcomes, which would prevail in a competitive landscape. Or the market is becoming so concentrated and it becomes vulnerable for the participants to come together and raise prices or indulge in other forms of cartelization. So basically, this is what we do in our assessment whenever a merger is reported to us. As Neha pointed out, we have done around 1,000 cases. Only in 22 cases we have imposed remedies. So when I say this, then people get a bit attracted towards those 22 cases where we have imposed remedies. But for CCI, facilitating those 950 cases in a matter of 17 days is a more bigger priority than spending our resources more and more in these 23 cases. So we are very conscious of the fact that more than cases which require remedies, facilitating cases that has nothing to do with competition risks is an utmost priority for us. And even in those 23 cases where we imposed remedies, only in 8 cases we have gone for phase 2 investigation. Phase 2 investigation essentially means there's a huge time cost on the transaction. If we say that a phase 2 investigation, ideally it may be around, say, 70 to 100 calendar days more of regulatory approval. You won't get the approval for 70 or 100 more days. So we were very cautious that wherever parties are forthcoming to give prompt remedies, then if that were to take care of the preliminary apprehensions of the commission, then we have dropped further investigation accepting those remedies. So the endeavor has always been to be transparent, to reduce the time cost on transactions, and our priority is to facilitate mergers. And the second priority is, of course, and very important, that wherever competition is getting lessened by a merger, and then as a result, consumers are losing their choices, prices are going to go higher, quality is going to get reduced, then those are the matters where alone we have intervened. Now, coming specific to and there are lots of facilitation measures which our secretary spoke about, which Neha also, clarified. Coming specific to digital markets, we are living in an era where almost all evolved jurisdictions have competition law enforcement. All of them have merger regulation. The last 100 years, we have a big baggage, the way we have understood the markets. But is that understanding sufficient or appropriate to deal with cases in digital landscape? That's where Neha said, whether the standard toolkit that we had for assessing, traditional markets, will it be appropriate and quite right for digital landscape? So those are whether our legislative framework is right now sufficient to take care of the modern market realities. So these are the challenges that are posed before us. When it comes to digital market, specifically, I would say there are three aspects which are of significance. And the topic is concerns in digital mergers. The concern is not only for stakeholders, even from a CCA perspective, I would like to speak about. One, why we exist as competition agency? It is to ensure that the mergers does not make the markets vulnerable for anti-competitive practices. So whether the merger is going to increase the concentration is the first thing that we will look into. But when we take digital markets, the norm is nothing but monopoly. If a platform is coming in existence to connect consumer and the producer, more and more it becomes the only platform where I can buy the goods. So maybe monopoly is bad is the MRTP regime. Maybe that's not a right mentality today. That's why the competition law does not see monopoly as bad. Abuse of monopoly is bad. Therefore, even in merger analysis, if a industry is getting digitized, as a result, a platform is becoming prominent and that becomes the only platform, to what extent it is a problem? They are becoming the only platform may not be the prime concern of CCI, rather whether this platform would engage in business strategies which will result or harm consumers. Yeah.
So just like we have a JAM portal
Yeah.
for government, in the similar way we should have government portal for private. Just like Amazon is taking a monopoly, as we talk about in digital marketing and digital payments, likewise, it should happen like this. Because the control should be government, everybody is putting their products on the portal, the equivalent to JAM, and it should be private, it should be a government one.
I don't know, when you say this, I'm not able to understand. You mean to say that there should not be any other online platform other than that platform? Or, see, I don't think so. See, when you say that, it's open for the government to float a platform. It's open for any player to operate a platform. If you are efficient, you're going to succeed. And if you're not efficient, you're going to lose in the race. See, yeah, but it's welcoming. Government may come up with a platform.
The problem is monopoly of the ratings move on.
So that's what I said. Sometimes it may be an industry feature that the platform becomes a concentrated and dominant player. That may be because of his efficiency. The anti-competitive outcomes associated with those type of business strategies has to be dealt in a very careful manner. It is a trade-off between efficiency, which is helping business and consumer on the one side, and anti-competitive effects. It's a very complex question.
The issue is the seller is dependent on the various platforms. Seller is dependent and they are issuing invoices on behalf of the seller. How can a GST invoice, without being made by the seller, and the Amazon.com issues the invoice on behalf of the seller to the customer, and then the money is routed after some time to the end customer.
Madam, because of paucity of time, I'm sorry to say we can have discussion during lunch.
I have completed everything.
During lunch.
Maybe I may not be.
And as Mr. Pawan said in the morning, you please send your suggestions in writing. All your suggestions will be shared with the regulators.
So I may not be the right person to address invoice issues in GST, but from a competition perspective, I feel that there are three aspects which are very important when we speak about concerns of digital mergers. One, whether CCI is having jurisdiction to really identify the digital mergers that are problematic, or whether the existing jurisdictional thresholds are such that some of the problematic transactions are not getting into the eyes of CCI. That's an issue. I'm not saying that it is a factor. The second thing is that whether the competition assessment which CCI conducts is based on the parameters given under the Act, that is Competition Act 2002, whether those are sufficient enough to analyze mergers in digital space, or whether we need any empowerment in that space. Lastly, if at all there is a competition concern, in a merger in digital market, what type of remedies we should really look for, because it's a fast changing market, it's dynamic, market system is so complex. You think this remedy will work in this market scenario. The market scenario is totally different in just a matter of 2 months later. Therefore, can you foresee, when you say that whether the regulator can impose a remedy to address a harm, then that crystal ball gazing or the foresight that you should have, it's very complicated. The way you have to empower yourself in analyzing those cases, then that also poses challenges. Now, I think because of paucity of time, I'll just get into some of the cases where we had concerns, how we dealt with. We all know that our foreign direct investment laws has a condition, for instance, those who are into multi-brand retailing, for that purpose, if they have an e-commerce platform, they should have they should not have an inventory-based model, which essentially means that you can run a platform for connecting a buyer and seller, but you should not be a person selling your goods in that platform. Why? I think it has some significance and relevance to competition enforcement also. This is called conflict of interest. If I run a marketplace and if I have a coffee shop in that marketplace, definitely, would I give a permission for anyone else to set up another coffee shop in that marketplace? That's the simple question, So this is basic common sense, it happens. So on the other hand, if a guy who is running marketplace can do business there, it may lead to certain efficiencies. It may be good for consumers also. So we have to really balance between these efficiencies on the one hand and resolve the conflict that arises because of the same person running the platform as well as engaging in supplies there. Just I'm giving one example. In one case, this taxi aggregation business, online taxi aggregation market, a car manufacturer wanted to make an investment. So that case came to us. Then we analyzed. As a part, apart from the investment, they were also entering into a commercial contract whereby the ride-hailing platform was intending to procure significant number of cars from the same car manufacturer. Then we asked, what is the necessity of these cars to you? Then they said that these cars may be plying in our network. Then we asked a question, will you give preference to those cars over and above others who are not connected to you? Then I think the parties really appreciated our concern. In the phase 1 investigation, it's just a matter of 20 days from the date of notification. They came back, they also realized that we do have a thing. And then we felt that if you were to prefer your own cars, then what happens to the neutrality of your platform? Can it harm others who are there in your platform? Therefore, they came and said that don't worry, we will run our algorithms on the basis of on the basis of objective parameters. It will ensure that we are not discriminating between different class of customers who are using our platform. On the other hand, if we say that if we are so strong about this harm also, the problem with the digital markets is that the way the boundaries of the markets are shaping up, you cannot be so certain. The classic example is that even in the ride-hailing industry, what was the market a year before, 2 years before, was much, much, much different. So you have to be extremely cautious. You cannot be over-assertive with theories of harm that are not probable. So you should have quite clear and cogent materials, internal documentation of the parties. Then you should have a credible case even to impose a behavioral remedy. If you are doubtful, ambiguous, then obviously we have conduct provisions to take care of abuse of dominance and cartelization. So, imposing certain unnecessary conditions or dragging the deal without approval for a considerable point of time, we have to be cautious. CCA is very much cautious about that. So this is just one example, where we had to, parties came up with a behavioral remedy. Then, yeah, we agreed to it. Yeah, I think, that we have. The CCA does that. If a remedy is imposed, we monitor it, we look into it. And then if it is not complied, we have powers to enforce our remedies and penalize for contravention. So that is there. I think, thanks for the opportunity. Because of time issues, I've just, pointedly, I took one thing and then.
Thank you. Thank you. I need to have, I think we should have another event on this Competition Commission of India and this is Competition Act and M&A, and we should be given at least an hour there. We have not done justice with you. Sorry. Now I come to Ms. Shweta Bharti, Senior Partner, Hammurabi and Solomon Partners, to speak on corporate restructuring and M&A issues under IBC.
Good afternoon, everyone. So when I entered into this profession way back in 2002, there was a lot of discussion around mergers and acquisitions. Section 391 to 394 was into play at that point of time. The majority of concerns that were raised at that point of time was primarily in relation to, if the increase in the authorized capital happens. So what happens in those circumstances? You should follow the procedure which is provided for increase of authorized capital or not. Or if there are reduction of capital implication in the scheme, then there should be a separate procedure followed or not. Or there were stamp duty related issues. So these were few buckets on which there were a lot of discussions happening, and then there were judgments passed, Mihir Mafatlal and onwards. There were multiple judgments which have been passed in this regard. Now we come to the 2013 Act, where we are talking about Section 230 to 232. More or less, the structure and format of the Act has not changed. The procedure which was followed by the High Court, the Companies Court of the High Courts, are still being followed by NCLT. But what we have seen over a period of time is that the intention with which the matters were shifted from the High Court of the company bench to NCLT, which was to have an expeditious decision on the matters, that has taken a backseat because of IBC taking precedence, and therefore there being a backlog in terms of the matters relating to mergers and acquisitions. So those are some of the pain points with which I start my discussion. And I think there was somebody in the morning also who mentioned that I think the High Court was doing a wonderful job, and probably there was no need for us to go to NCLT for the Section 230 to 232 matters. However, that is a point which we can deliberate upon and talk about a little later as well. Now, coming back to the issue where, IBC has become a pet baby for us to talk about. The point of discussion in IBC, I think a lot of people have already spoken about, from Bhushan Steel to Bhushan Power and Steel Limited, JP Infratech, Alok Industries. We have seen a lot of bigwigs which have gone through this route and have been successful in this route. But what we have seen here is that the administration which is being done by NCLT, the IBC has regulated the auction sales under the CIRP process. And IBC has played a very critical role in bringing back the economic balance prior to the pandemic. The IBC assisted in resolving the problems of increased stressed assets by offering the stressed assets to the interested bidders at a very competitive price, with the hope that there is success in combating COVID-19. The next task in hand for us would be to bring the economy back into place. And I think IBC might come to the rescue in this regard for achieving that economic balance. In fact, in 2019, there was an amendment which was introduced to the IBC where Section 5 of the code was amended to clarify that the resolution plan may include the provisions of restructuring of the corporate debtor, including by way of merger, amalgamation, or demerger. Though, in fact, NCLT had given accent to this kind of a provision, I again remember somebody talking about it in the morning, was in the case of Synergies Castings and Synergies Dure, where they had accepted this as a process for restructuring as well. And in recent times, I think the statistics may be improvised, because what the data at the moment says is about 12% of the M&A deals which take place it takes place under the aegis of IBC. There's another solution which probably we are looking at is in terms of pre-packs, which have probably been introduced at the moment in the current legislative framework for MSMEs. Could be one way of looking at resolution of distressed companies outside of MSMEs as well. So while Section 230 of the Companies Act gives significant importance to the shareholders, and Mr. Madan has made a mention about the consent requirement, because Section 230 to 232 does not talk about the dispensation of the meeting for the shareholders as such. So unless and until we have 100% of the shareholders, consent in writing, even then, in certain circumstances, NCLTs in different benches have rejected that request for dispensation, but most NCLT benches have allowed that kind of a dispensation. So in cases of Section 230 to 232, where you give a lot of credence to the shareholders and their thought process in terms of business, in case of distressed M&As, Under IBC, it does not give that kind of a right to the shareholders. So it becomes imperative to understand the procedure which is to be undertaken so far as the distressed M&A transaction under IBC in depth is concerned, and how it is different from the scheme which goes under Section 230 to 232 under the Companies Act for companies which are not distressed. Moreover, the distressed M&A in comparison to the normal M&A has got its own advantages and complexities as well. So transacting a distressed M&A under the IBC may require just complying with the procedural formalities. But the resolution applicant should have the certain level of skill set that is required and the risk appetite to close the deal successfully. So the IBC does enable an interested bidder to present a resolution plan to the committee of creditors. In fact, generally a resolution plan involves a proposal which includes a partial debt waiver, a partial interest waiver, and conversion of loans into equity, and among other matters. The resolution plan also assists in the revival of a corporate debtor which is under the IBC proceedings. In fact, we have heard a lot about the role of the Competition Commission in the process of revival of the stressed assets, and therefore I'm not talking about that because, of course, the Regulation 37(1) of the IBBI, which also requires, that there is a provision for statutory approval to be taken from the concerned authorities, but the timeline for such approval from CCI was not mentioned there. So subsequently, with the 2018 amendment, I think it is clarified that such approval from CCI must be sought before the approval of the resolution plan by the COC. And such approval is to ensure that the resolution plan does not provide undue advantage to the resolution applicant with such takeover of the corporate debtor through the resolution process in any manner. So with the mandatory nature of approval of CCI for a certain threshold and above, there are apprehensions that delay that may be caused in the CIRP process, since the CCI can take time, though we have heard that they are not taking time, can take time for granting such approval of the resolution plan, which can make things go haywire in terms of the meeting of the timelines. There are other challenges as well in this regard, since in terms of Section 2A of the Competition Act, no combination can come into effect unless and until the 210 days have lapsed. So while the CCI may be sensitive about this factum of timeline constraint, there may arise certain conditions or circumstances where there are likelihood of delays, which may defeat the strict timelines contemplated in the code. Also, the risks that are involved in the M&A of a distressed company is unique from the M&A of a non-distressed company. So the buyers in this case do not use the standard contract clauses like the indemnification clause. Further, the buyers involved in M&A of a distressed assets are more protected under the bankruptcy code regarding the unwanted liability. But one of the most sought-after aspects of the IBC mechanism is the time period which is allotted to agree to the terms and deal with distressed assets on an insolvent business. So the IBC provides strict timelines for the completion of the various stages of the process, and the maximum time that is given for the resolution is 9 months with the grace period of 90. Although the process sometimes exceeds that timeline, we have seen that also happening, it is still more effective than the court-driven process. This means the process and valuations of the distressed assets are carried out faster when it is carried out by merging and acquiring entities while conducting the due diligence on non-stressed assets. I think there are a lot of discussions which have already happened with respect to the due diligence, and therefore I would not talk about too much. But then, of course, there are certain safeguards which are required to be exercised while doing the due diligence in order to ensure that we do not fall through the cracks, which may make the M&A transaction unfavorable and troublesome also for some investors for that matter. So IBC, with the initiation of CIRP, suspends the board of directors of the distressed companies and places the IP at the helm of the organizational and fiscal management of the company as a going concern. Thus, with the suspension of the board of directors, the officers and managers of the corporate debtor are required to report to the IP. This also means that it is the duty of the IRP now to protect and preserve the corporate debtor's properties and manage the operations of the corporate debtor as a going concern. So if a plea of insolvency is submitted to the NCLT by financial or OC for the corporate debtor itself, it is admitted by NCLT and the CIRP is initiated. In fact, there was some judgments also which I wanted to talk about, but I'm avoiding because of the time constraint that we have, and maybe we can talk about it offline. But what is also important to touch upon a little bit is about the capital gains, because now under the new provisions of the section 230 to 232, there is also a requirement to take the consent of the IT department, which was not there in the earlier section 391 to 393. So there are certain elements of capital gains with respect to which there is an exemption given under the IT Act, subject to the satisfaction of conditions. And there are business losses and unabsorbed depreciation also of the amalgamating company, which may be allowed to be carried forward and set off in the hands of the amalgamated company, but again subject to certain conditions. And the business losses may be carried forward for almost about 8 years pursuant to the merger, subject to certain conditions. And these, though they are looked upon very carefully by the regulatory authorities, and for the purpose of merger, the merger should not be used as a tool for set-off of losses, and therefore there are closer scrutiny around this. But then relaxations have been provided by the government for the carry forward of losses in case of companies under the IBC, where the insolvency resolution plan involves change in the beneficial owners of shares beyond 51%. In that case, the tax losses may still be available pursuant to the approval of the resolution plan under the IBC, and additional relaxation with respect to the tax issue may contribute towards the smooth functioning of the IBC process, and would promote more IBC participation, thereby giving a boost to the acquisition plan. That is, in fact, what the whole thought process is. And with this, in fact, I also wanted to talk about ESG, but maybe on another day, because there is a lot to talk about with respect to this ESG and supply chain optimization, where we are seeing the companies now adopting to these kind of methods in order to ensure that post-pandemic transitions, which continue to bring significant challenges, such as supply chain disruptions, skills shortage, climate change complexity, cross-sector convergence, there is a need and the scope for traditional M&A strategies to include collaborative structures such as ecosystem alliances, partnerships, and other similar constructs that are not bound by the traditional industry boundaries, but instead coalesce around common purpose and create shared value for the businesses, their clients, and their communities. So with the opening of several sector and the investor-friendly reforms being brought in to facilitate the ease of doing business in India, we anticipate an increase in the quantum of investments being made in the country in the future, and there will be greater involvement of technologies in M&A, including the use of artificial intelligence for e-discovery, intelligent data rooms, as well as contract review. So the future for M&As are definitely bright, with more focus and attention on the regulatory and procedural aspects, and the time-bound manner in which it is envisaged to be completed will go a long way in making for the progress in leaps and bounds. So thank you so much for your patient listening.
Thank you, Shweta. You have raised so many issues in less than 10 minutes. You raised the issue of carry forward tax. In the morning, Mr. Pawan Vijay raised the issue of funding and M&A. He raised the issue of holding post-merger holding of the acquired company of 75% equity in the company. I think all these issues have been taken care of under IBC. So that's the plus point of this insolvency and bankruptcy code. You talked about timelines, but unfortunately, in the recent order or judgment of Supreme Court has said that all the timelines under the code are directory in nature. Earlier, couple of timelines were there directory in nature, or some of the regulations were being said directory in nature. But now Supreme Court has said all the timelines under the code are directory in nature. And it is going to have far-reaching impact on the success of this legislation. Shweta, you also talked about CCI approval before the plan is approved by Committee of Creditors. I will request later on when I invite Dr. Sanjeev Gemawat, to touch upon this issue. I think he was witness to this issue in case of Binani Cement, when this issue was raised at that point of time. Now I invite my friend Mr. Ranjana Roy Gavai to speak on to wherever you have left to take it forward, that how M&A and the resolution plan and the resolution applicant, what issues you take into consideration while giving a plan.
Thank you, Mr. Madan. I think I'm audible, friends. Well, I'm quite conscious of the fact that the time is very, very short. And in fact, I see the overlapping of the topics in the morning and in the afternoon. I mean, Shweta has been given to speak about IBC and acquisition and merger, and now I have been asked to cut short and carve out, further niche out of that, and I should focus only on, the resolution plan and how it helps in merger and acquisitions. As Shweta rightly pointed out, after the IBC coming into picture in 2016, we've seen, the fastest way of acquiring or, taking over the company through this process in a time-bound manner. If we see that route was available prior to IBC under the Companies Act, High Court, even if it used to try to close it in a shorter period of time, but normal timeline was around a year and a half and 2. Under IBC, the acquisition, especially, for the resolution applicant, those potential resolution applicant, the interest arises after the admission of the matter. So it's very, very important for, the resolution applicant to do the homework. That would include, potentially looking at the target company or the corporate data, where it has to actually see whether it has got an interest, business interest for acquisition, or if it wants to, horizontally acquire some more business for the investment perspective. So all these things are available. I would say this is a beautiful piece of legislation, especially for those who are interested in acquiring the business. Why? Because you have everything, monitored. For example, if you're acquiring a business privately between the two shareholders, though you have refs and warranties, but you may not have that kind of a protection which is there under the IBC. Because for the purpose of a due diligence, all the data are already, at place, which has been conducted by RP, the resolution applicant, which, enlist all the assets, all, the liabilities, doing the financial due diligence by way of forensic audit. And in that transactional audit, it is able to bifurcate whether there is a fraudulent transaction, whether there is a preferential transaction, avoidable transactions, and all those transactions are actually avoidable, and you can very well cover in your resolution plan. And you can do the value. Insofar as the valuation is concerned, that is also provided well in time, so you really know what is the value you are going to acquire for that particular business. So all these things are available. And not only that, I would give example. For example, Daiichi, when it acquired Renbexi, in spite of the refs and warranties, it was not aware of the fraud played, which, the fight went on up till the long time, though it was able to, get the damages back, it has not been fully recovered. Whereas under IBC, all Big 12s, all of you are aware. This way or that way, I was involved in at least 9 to 10. So I'm aware of this, the moment bankers see that now it is getting NBFC to, save its own skin. Moment there is a NPA, it will, declare the accounts as a fraud. Moment the account is declared as a fraud, it is shared with the CBI, all those agencies, Serious Fraud Investigation Office, and then ED. 3, investigations simultaneously starts. So now the issue arose that in spite of the fact that after the resolution plan is approved, the new incumbent is coming in as a resolution applicant, what are the protections? Ultimately, this issue was decided in Bhushan Power, though that issue is still pending in the Supreme Court. But government realized it very soon and brought in amendment 32A, where the successful resolution applicant will not be amenable to the past liability. So those are important things. And this is also provided under the law. Earlier there was, on the basis of a forensic audit, on the basis of transactional audit, it is incumbent, and now again, as Mr. Madan rightly said, that is though it's a directory in nature, but you'll have to file before the court that avoidance application, fraudulent applications, within 75 days, so that the resolution applicant is aware that what are the value it has to exclude and what are the recoveries it can make even after acquiring the business, and that can be added in the value. Now, the second issue, which is also very important, I mean, in most of the cases, especially in the steel industry, it was a kind of a windfall. Because what happened, all steel industries in a one go went into, IBC. And the market, there was a market boom insofar as the steel industry is concerned. So during the CRP period, there was a good EBITDA and there was a good revenue accumulated, 5 to 6,000 crores, 7,000 crores. So all those benefits also were given to the resolution applicant. Though one particular issue is pending, insofar as Bhushan Steel is concerned, Tata has acquired it, and Tata had put in its resolution plan that during the CRP process, whatever is the accruals that it will acquire. In case of JSW, in Bhushan Power's case, JSW had not specifically provided in its resolution plan. So therefore, that fight is going on. COC has filed the petition before the Supreme Court by way of SLP saying that no, that money should be given to us. And JSW is saying, no, I mean, during the CRP period, since there is a stoppage on that particular day, so whatever would be the resolution money provided by the resolution applicant, he will be entitled for that. That resolution has not, that issue has not been given quitus to. That's another aspect. And the most important aspect by way of this acquisition is again timeline. I mean, though there is a timeline of 330 days and maximum, depending upon, suppose it's in that infrastructure where it really takes time. So that timeline has been increased to 440 days. But we have also seen, because there is a provision now for the exclusion period, there is a provision now for enlargement period, then obviously, I mean, what is the objective? The objective is, to maximize the distressed assets value. And for that, the courts are also lenient, and even the bankers also know if they will be very particular about objecting to those extensions, they may not get what they are going, because obviously the liquidation value is very, very less than in comparison to your value under the CRP process. And the avenues are available. Since there are amendments after, in 2018 and 19, we've also seen, outbound or inbound acquisitions. And I was quite surprised, to see the data. In fact, outbound acquisition is more available during this period than the inbound. It should be other way around, which will bring more foreign investment. So I think we have to really think about how to make it more attractive. So there are a few suggestions. After that, I think this will be a good avenue for, acquiring through this process. Is that all, Mr. Madan?
Thank you. And this is what the issue was raised by Mr. Pawan also in other way in the morning, though he's going right now, that funding in acquisition is not still allowed, but under IBC that issue has also been taken care of. You also talked about this avoidance application, but two issues are yet to be decided, that post-approval of the plan, who is going to pursue these applications? That is a major issue, not yet decided. Whether it be RA or the RP,
well,
or the IRP, or maybe liquidator, whosoever.
Yeah, I'll tell you about that. That issue is pending before Delhi High Court Division Bench. In fact, I was the one behind this whole litigation. Venus recruiters have decided this issue, Delhi High Court, and we recently argued it in Division Bench. It says that adjudicating authority also becomes functus officio in terms of the section itself. And RP also will have no right, because moment there is a resolution plan, it becomes a normal corporate, and whatever are the process of recovery, then through that process you can process. It can, the new resolution applicant who has come into the shoes of the corporate debtor can actually proceed in a normal course. Like
he will only if the money comes to him, if money, if any, recovered.
Of course,
money, if it recovered,
course.
yeah. Okay. Thank you. Now, friends, some days ago you must have heard about that Gautam Adani has attained the third richest person's position in the world. Today, an hour ago, there is a news item that he has attained the second position. But friends, we have somebody with us who is second to none as far as India is concerned, as far as professional qualifications are concerned, Dr. Akhil Prasad. A dear friend of mine, And he's ably supported by Dr. Sanjeev Gemawat. I tell them, I address them as Ram Lakhan of professionals or Karan Arjun of professions. Sanjeev, hope you're listening. देखा एकदम आ गया नाम लेते ही आ गया स्क्रीन पे.
I'm listening here only.
So now the ball is in court of both of you. Whether you're playing singles or doubles, you need to decide it, because both of you will be speaking from industry's perspective. Both of you are having experience in multiple industries. Akhil has remained with number of for multinational companies. Sanjeev has served with cement and steel and blah blah and whatnot. So whatever industry or industry as a whole you want to choose, that's up to you. Okay, let's first hear him out. And the other way, he'll move away if you hear him. Otherwise, I want him. Yes, you will not keep your video off then after your speech is over.
While I am speaking, he will not keep his video.
Okay. Yeah. So over to you, Sanjeev.
No, so Akhil, you carry on, then I will add on that. Yeah.
Bit loud.
Yeah.
Okay, so let me start. So how many of us are aviation enthusiasts in this room? Aviation. How many people like aviation? Others don't like aviation? You don't like traveling? You don't go out for holidays? Of course. So, for all aviation enthusiasts and for people who have not raised their hands also, I think there is a lot of good news in aviation, because I think a week ago, there has been a release of Global Aviation Outlook. So this is a benchmark study which is done globally for all aviation companies. And this exercise is being done for last 6 decades. And it has always been very, very accurate. Even during the COVID times, the predictions were very, very accurate. So the numbers of aviation for next 20 years. So today we are sitting at a global fleet of, and I'm only talking about commercial aviation, only the commercial aviation. So today in 2022, we are sitting at a fleet of 25,000 planes globally. And the prediction is that by 2041, the fleet size will be 42,000. So a phenomenal growth. This is a global outlook. But when we look at India, today we are at a fleet of 800 planes, all carriers combined. But in next 20 years, India will need 2,500 additional planes. So this is because of the good news about Indian aviation. So we were at a seminar like this, last year and in 2020, when COVID had struck, big time. And everybody was saying that aviation industry has gone, it will not recover for many years. But our company made an announcement that we foresee that by 2023, the industry is going to be back. And if you see today's Eco Times, the news says that India is already past the COVID levels in terms of aviation traffic, right? Now coming to the topic, because while we were having tea, Madan Saab promised me that he will grill me in this session and I will get my 3rd PhD. So taking that forward, let me talk about, last 2 hours we've been listening, and we have a lot of experts talk about what deals, transactions have happened, but perhaps what got a little missed, and perhaps what I will add, is about the aviation industry. So in the aviation industry, we have seen everything. We have seen Government of India selling Air India, which has perhaps been approved by CCI, that they want to now acquire AirAsia, which is what we read in the news. And then Tata Group has announced today, their CEO has said that he's going to target at a market share of 30%. 30. So the largest carrier today is Indigo, which is at 57%. And Tata Group has announced we will take 30% of that share. Air India, disinvested by government, now it's Tata company. Let's turn to another carrier, Akasha. A startup coming into aviation, And this is perhaps, India is one of the very few countries where we have seen a startup coming into aviation. We have seen Singapore Airlines investing in a joint venture, big players. But here, if you see, Rakesh Jhunjhunwala ji, who unfortunately passed very recently, there is no major shareholder in this company, which is an airline. So big players start startups, but here we have Rakesh Jhunjhunwala as somebody who's backing an airline, with two former CEOs, Aditya Ghosh, former CEO of Indigo, Vinay Dubey, former CEO of Go Airways as well as Jet Airways, being co-promoters. So a startup coming into a very big way, and I had a very, I was very fortunate that last year in August, while we were, 400,000 COVID cases in India, 400,000 cases in the US, I was asked to join and participate in this transaction of Akasha. So I got a very deep insight about how CEOs think. And what I learned from that meeting was, here is a startup who is very clear that in next 5 years, we will touch 25% of the market share. So this is the belief of the future that aviation has for India, that even a startup which does not have an airline background as an investor, only people who have been former CEOs and a big investor has that courage to come into an industry which is so difficult. We have seen Jet Airways sink, we have seen Kingfisher sink, although backed up by some very, very big groups, but a startup is coming forward to do business. And then the third and the biggest, a big one, is perhaps Jet Airways. Jet Airways, once the largest airline in this country, went into bankruptcy, now wants to come back again to become a key airline in this country. And, we have seen a lot of cases which are before the NCLT. And, the question, which is asked of me by our people in the US is, if there is a Chapter 11 case in the United States, there is some finality to that Chapter 11 filing. But in Jet Airways, we have seen an NCLT order last year, but a lot of cases have been admitted at the NCLT level, and there is still no sign of when those cases will be decided. So the investors are questioning, for Jet Airways, what should Indian government do to give a finality to the NCLT order? Whether there should be a finality of the NCLT order, or it should work like another court system where you go in for appeal and derail the entire process. So that is a question that all of us perhaps need to answer. So aviation, in a way has a great potential. So this is on the airline and on the manufacturing side. But if we look at the National Civil Aviation Policy or a Vision 2040, which has been initiated by the Government of India, we are talking about regional connectivities. Every big district of this country will be connected through airways. There are, you said about the richest person, and the richest person is investing heavily into airports. And the entire landscape of this country will be changed by having, the target is to have 100 more new airports. If we are complaining about what is happening as T3, we will already have an airport in Zevar very, very soon. And Zevar is just an example. Bombay perhaps will have one more airport in Navi Mumbai, and so on and so forth. So it is a tremendous potential that this industry, aviation industry, will put this country forward for at least next 30 to 40 years, not only in terms of starting new airlines, but also in terms of developing the infrastructure. So this is how I see. Sanjeev, what do you think about the industry participation and how industry is looking at the regulations?
I completely agree with you, Akhil. Of course, you have focused on the aviation industry, but then I think the related industry is also the defense, which would be prominent industry in the times to come. But then if I give a perspective on the whole issue, it appears to me that in a situation where today we are the fifth largest economy, with a nearly 7% plus kind of GDP, and where the perspective here is worldwide that there's a China plus one policy. Now, we will have to give this a perspective that of 7% GDP growth, China plus one policy, then fifth largest economy. And you are talking about the aviation industry, but then I'm talking about all those industries where you use technology. Like, for example, aviation is one, defense equipment is another industry, and then today we are entering into the semiconductors field also, which is nearly a huge market, nearly a $200-300 billion market in the times to come. And also, if I need to give it a perspective, today Indian corporates are becoming large and they are acquiring companies worldwide. I think with this kind of thoughts, where Indian corporates today, somebody, I listen very Somebody mentioned about the ESG focused approach, and of course, indeed, this is very true that Indian companies, Indian Inc. today, they are focused on the ESG principles. Now, in this backdrop, we will have to see the M&A activity, which is the theme of this presentation, also the theme of this conference. M&A activity, to me, it appears that M&A activity is basically a reflection of maturity of the Indian economy, or the reflection of the maturity of any economy. Because M&A activity in itself suggests that there is a competition in the market, there are sufficient number of players in the market, there is a transparent process in the market, and above all, there is a mechanism available in terms of giving that facilitation to the M&A activity. I listened very carefully Mr. V. Sriraj when he mentioned that there are only 22 cases out of 1,000 odd cases that where certain modifications have been suggested, and it is very true. A competition commission, a regulator today, which is, and if you see the history of the CCI, it has become a such a facilitator kind of a regulator, whereby all M&As have been approved. There is no one single M&A which has been rejected by CCI. Of course, in some odd 22 cases they have given some modification. So we are in this kind of framework where we have there's a contours as far as the economy is concerned. There's a sufficient level of maturity in the market, and there's a sufficient level of legal framework existing in the market. Whether that is a competition law or whether that is today's arbitration law, the company law is in a new form altogether, and above all, we have IBC available in terms of bankruptcy related issues. I also agree with one thought that yes, in the process there were some drawbacks in the process. Of course, IBC, the way in which we look at the IBC, it was an absolutely revolutionary law, no doubt about it. But then yes, somewhere we have compromised, in terms of the mechanism which we followed on the IBC. It has proved to be so far, I would say, so far it has proved to be an inefficient system, perhaps because of the delays and because of the inefficiency in the overall system, whether we can blame it to the less number of judges in the NCLT or NCLAT, or perhaps the approach of the overall justice delivery system. We have compromised on the mandatory timelines kind of thing, whether we use the word mandatory or directory. The fact remains that the legislation provided a certain time frame to resolve the bankruptcies, but then we failed miserably in terms of this. We failed, in fact, if I see the data, if suppose overall 14% of the cases have been resolved, then I see that there are challenges. But so, despite of all these challenges, despite of all these systemic issues, I think we are in a comfortable position today. If I even post-COVID, 2021, a COVID period, then still the M&A activities were at its peak. 2022, the first half, the way in which we see today, the kind of number of deals which happened, perhaps over 125% higher than the last year's first half. So it gives me a positive outlook as far as overall activities are concerned. Overall, I am very optimistic about the situation. There are certain drawbacks or inefficiency in the system, but then I think gradually we would address that. I also see a huge potential in the times to come, because today we are on the verge of the reforms, or what we say the fourth level or fourth generation of reforms, I would say, the industrial revolution, what we say. I think today Indian industry is adopting the best of the technologies available. They are very focused on ESG, and this is where the time to go, I think. So I see a lot of potential in terms of M&A activities. I see a bright future for the Indian corporate sector, and so is the professional like Akhil, you, me, Mr. Madan, Ranjana, and everybody, Shweta, and everybody. So this is what I think. I took Mr. Madan only 3 minutes. Thank you very much.
Thank you, Sanjeev. Thank you so much. Great, excellent. Santosh, I have one request to you, because I really took it very seriously when Dr. Akhil said that when this NCLT order will be given finality. Actually, these issues actually going to derail our ranking in ease of doing business. I think from the chamber side, if you can be in touch with him and other professionals and send a note to the concerned ministry. I don't know who is the concerned ministry. Maybe better you go to PMO. I think, yeah, Because MCA और Ministry of Finance में जाने से मुझे लगता है कुछ होगा.
May I mention one more?
Please.
So we started a fast track merger in 2019. We got approval this year.
Fast track. 2 साल अपने आप ये कहा ना एक्सक्लूजन पीरियड, तो कोविड एक्सक्लूड हो गया ना 2 साल का, तो 1 साल में हो गया फिर तो. Okay. So friends, now over to Mr. Kunal for his last address of this session, pre-lunch. Role of private equity in mergers and acquisitions.
Good afternoon, everyone.
Kunal, please, you have a very tough job.
Yes, being mindful that I am the last one to keep you up from lunch, I'll try to make it very pointed. So of course, private equity investments are obviously very important for the economy and in general and M&A activities in particular. Obviously, when COVID hit, everybody became circumspect. But I think after a lull, 2020, as we have already discussed, 2021 saw there were big numbers. The private equity investments were back in the big way. The all record-breaking numbers that we talked about. The trend continues in 2022, and obviously the hope is that it will continue for years to come. Of course, the focus of investments changed dramatically. I mean, the focus now, of course, is on sectors like pharma, IT-enabled services, digital, healthcare, and education. I think the scope of due diligence and valuations has changed forever. In addition to obviously the normal check boxes that we tick, I think definitely some focuses are on how the businesses are equipped to handle unpredictable disruptions. Right? Of course, ESG factors becoming increasingly important like never before, and the ability to switch to remote working. I think that's the key. So these are additional factors that have become increasingly important. On the regulatory front, of course, a lot has been talked about. So PN3, Press Note 3, of course, it's important. It had direct impact on private equity, especially entities, which had ownership links to landlord companies with India, especially China. Clarity should be there. I already talked about. SEBI issues already been talked about in detail, so I will not touch upon again. Another, obviously, incredibly important regulator is the Competition Commission of India. A lot has been spoken about, by the esteemed panelists earlier, so I will not repeat, but I must emphasize some points from private equity perspective. I think this was, CCI, one of the first steps that they took right in March 2020 itself, just with the onset of the pandemic, is introduced electronic filings and, video conferencing of meetings. I think this was a absolutely incredible step, and I think CCI deserves really kudos, and a round of applause for that, because they did not, let the pandemic affect any of the transactions. So I think, thank you so much to the Commission, and especially everybody in the combination department for that. Green Channel, of course, has been talked about while it came a few months before the pandemic in August 2019. But I think of the almost 61 filings that have been made in this route, I think private equity has been the biggest beneficiaries with more than almost 54%, if I see. So definitely this has been a great savior, this route during the pandemic. Again, in April 2020, rather in March 2020, there were clarifications given by way of guidance notes that has already been talked about. So again, this, the determination of overlaps, there was guidance which was very helpful from private equity perspective, because for the first time, there was clarity in terms of, what kind of percentage, there anything more than 10% shareholding needs to be factored in those entities. Even where there's an observer, it has to be factored in. So a lot of clarities came, which while it made things more cumbersome for the industry from private equity perspective, because they obviously have investments in many entities. But this is, I think, the clarity always helps. Then there was obviously a decision in Chris Capital Intas case where for the first time, in a private equity, a remedy was sought for in case of a minority acquisition. It could be looked at both ways, but yes, I think definitely it can be argued that Commission had their, arguably their justifications to seek that remedy in that case. Competition Amendment Bill, of course, has again been talked about a lot. So yes, we are looking forward to codification of deal value thresholds. We are definitely looking forward to crunch timelines, of course. Although we'll have to see how it eventually plays out. CCI is already undertaking a market study with respect to private equity, especially being mindful of minority transactions, stakes. So a lot of light should be shed once things are more formalized from this. As a practical takeaway, I will say, I think two aspects which we have seen, especially recently, and I think which have a potentially far-reaching implications. So I would just like to make 2 points. There is a less talked about but a very important provision in our Competition Act. It's Section 53N, which enables a person, and it's not any party to the litigation. It says any person can make application to claim compensation, before the NCLAT against an order of the CCI or of the NCLAT itself. This, I think, has a potential of really tremendous values that can, the factorings that need to be mindful of. Just to give you an example, we are doing a compensation case wherein, the original penalty levied was X, but the compensation claim was filed for almost 25X, So this is something increasingly, even in due diligences, we are very consciously seeking clarifications, and reviewing the litigations in this light, because this is something which definitely needs to be factored in. And likewise, in the same breath, I think it is very important to see that whether the companies have robust competition compliance programs, because invariably, there are, the mindset is that, okay, this is customary, these are business practices, but they do not realize that, in continuing with those practices, they are actually falling foul of the law. So we do a lot of competition investigations, and invariably, very, very big issues come out of that. So I think these are some points which I wanted to specifically highlight, and I hope I have, adhered to the timeline, and sorry for keeping you off from lunch. Thank you so much.
Thank you. Thank you, Kunal. And with this, we come to the end of this technical session. My sincere thanks and gratitude to all my co-panelists. Thank you so much. Over to Santosh. Thank you.
Thank you very much, all the panelists over here in the second technical session. And unfortunately or fortunately, from the beginning of this session, I couldn't interrupt in between of any one of the speakers. I was getting enforcement from Madan sir to please interrupt to one or other of the session in the previous session, but the enlightenment was coming so much that I could not dare to interrupt in between. And thank you so much for having you with us. And lovely audience over here. I find that this audience is most sincere so far on this subject. And they are presently here, and I'm so up. So I invite all of you for having the lunch and come back. We seek that we start sharp at 3, so that you please be on time. I request all of you to have the lunch and come back. Thank you so much, sir, all of you. Ma'am. M&A in times of digital economy disruption and transformation, sectoral issues and challenges and alternative financing options. Ladies and gentlemen, we have very, very eminent speakers of this session, and the session will be moderated by Dr. Rishabh Garg, Associate Professor with National Law University, Delhi. We have been joined by Mr. Sujoy Bhatia. He is a partner and head corporate law group, Chandiok and Mahajan Advocates and Solicitors. May I request and welcome Dr. Rishabh Garg and Mr. Sujoy Bhatia ji to please move towards the dais and take the seats. We have Mr. Ashish Agarwal. He is the director with the Resurgent India Limited. Please join us. May I also request Mr. S. Abdul Rashid. FCS FIPM, practicing Chartered Secretary and former Council Member, Institute of Chartered Secretaries of Bangladesh. We welcome you, sir. And our eminent speaker, Advocate Venkat Rao, founder and managing partner, Integrate Law Offices. He will be joining us virtually. May I request Dr. Risham Gargji to please take over the progression of this session and take over the mic, please. Thank you. There's a PPT also. Okay. Sure.
Good afternoon to you all. After the lunch, the situation is slightly, people get drowsy and slightly, not in the interest of listening. But I'm sure we have an interesting panel, and the topic is also equally interesting. We have a very good set of speakers and interesting presentations as well. And the topic is also very contemporary and topical. So welcome to you all to this panel 3, the last session of this ASSOCHAM conference. And the theme, as you are aware, M&A in times of digital economy, disruption and transformation, sectoral issues and challenges, and alternative financing options. So they've compressed quite a lot into this theme. And I'll start by providing a basic overview of what is the M&A scheme in this digital economy, right? And also taking reference of some of the key recent deals, M&As in India, regarding the digital economy space. So as you see here, that some data, some figures, which are quite, encouraging, very positive figures. So India had this 82 billion M&A deals, and this is the highest on record in India. And it says that this is more than twice as much as the previous record of 38 billion. However, globally M&A volume has declined, but in India, it has increased. So it means that India is still, and it is very attractive in the current times. Yeah, next please. Thanks. So what is M&A in the digital economy? So as you can see, smart devices, online platforms, blockchain, cloud computing, hyperconnectivity, and technology acquisition. And so businesses are continuing. There is a wide and greatly increasing retail sector, the changing demands, new consumption patterns, and certainly new platforms as the business models. Now, platforms as business model in such a consumer-led economy, and the businesses are using acquisitions to enable new ways of making payments, buying insurance as investments, offering loans, giving wealth advice to add value to their core products and services. Now, enabling innovations like blockchain, providing robust digital infrastructure to transform settlement clearance services, we are certainly seeing great customer-oriented platforms becoming major targets for acquisition. Certainly, we have seen few issues in these platforms as well. So, blockchain, there are certain issues. It is open, and recently, just today, we have seen that as far as the transporting logistics with respect to gold is concerned, the e-way bill will not be on the blockchain because there are certain privacy issues, and there are security issues as well because it's open access. But again, on the better side, because the logistics are on the blockchain, it is transparent and it is easily accessible to all the parties. Then an example, it's a famous example. PayPal acquired Braintree Payments, and Braintree turned PayPal into a one-stop payment gateway for merchant acquiring services and payment processing around the globe. So this is a very interesting ecosystem that we have, which is driving the entire M&A system as also the growth of economy. So key M&A in the digital economy in India, and we can see the firms are positioning themselves for a changed landscape in technology. And there is volatility in the markets, but we have to take care of these aspects. So recent interesting deals in India, the merger of Mindtree with L&T, then Indus Tower and Bharti Infratel, the Z merger with Sony. It's still some concerns are there, however, it's just going to go through. Then Akash merger with Byju's. Then some of these PE deals were dominated by the startup, edtech and e-commerce sectors. Some investments, as you can see, BlackRock invested $800 million in Byju, and Bodhi Tree invested $600 million in Allen's Institute. Then Bain Capital invested $500 million for 25% stake in IFL Wealth Management. So there are financing methods, funding methods. We have investment banker who is also going to provide interesting perspectives on investment banking in the digital economy. So digitization trend, what is leading the digitization? It's certainly the consumer, it's consumer economy. There are a lot of disruptions. We saw the disruption caused by the aggregators, Ola, Uber, then these e-commerce websites. So big change in the mindset of the people buy. Enterprises interact commercially post-pandemic, create a hungry and willing to try customer base across the segments. Then there is a need for infrastructure for the digital commerce. Penetration of mobile internet, cloud companies, information security startups, catalog proficiency, and also price management software. Need to understand the customer trends, and develop ecosystem around the influencing and customize offers on the several various loyalty programs. So loyalty programs are also, we see these NFTs, non-fungible tokens. There's a lot of value in these loyalty programs. And you might remember during the insolvency resolution of Jet, there was a huge issue of, this loyalty program. What is the value? Probably it was a great value proposition of the Jet loyalty program. Then ecosystem establishment, customer and supply chain alliances and logistics, last mile delivery, etc. And there is increased impetus in the ESG awareness. So what is the today's situation? So given the evolution of our digital world, how do we identify the right type of lawyers, but also, the several professionals. We need investment bankers, we need valuers also, is a huge issue of valuation of these digital assets. There's a lack of, physical, as we know, physical or tangible or corporeal assets. So what is going to be the valuation? What is the stock market value? What is the perceptible valuation on which the funding will be provided? Then staying relevant and up to date with innovative technologies may just be the most important key to unlocking the most value out of an M&A deal for the client in the digital economy. So we have curated some key issues for consideration. There are certain questions, and this has been put across to our panelists. And as after the panelists, they will be provided opportunity to make their presentations. And after they have presented, we will ask certain key questions based upon their themes. So some key issues I have been identified here, and we'll take up as and when the panelists have completed. Thank you for this patient audience for this presentation, and I'm sure you'll have several questions to ask from the panelists. And without taking much delay, I hope this introduction was sufficient to provide for a basic appreciation and introduction to the scheme, what we are going to take up in this panel. So with this, I invite the first panelist, Mr. Sujoy Bhatia. Mr. Sujoy Bhatia is a partner in Chandyok and Mahajan Associates, and he'll be speaking on M&A and joint ventures.
Good afternoon, everyone. While the presentation gets sorted, there we are. I think the digital economy and disruption are bylines for essentially a changed regime. When we used to do M&A 15, 20 years ago, there were two ways of doing a transaction. You either acquired a minority or a majority interest, or you acquired the entirety of the target, or you ended up creating essentially a joint venture between two either equally placed or dissimilarly placed entities. Over the years, joint ventures have remained a focus area for more established business houses. So just to take a couple of examples, Starbucks in India is a joint venture between the Tatas and Starbucks out of the US. We haven't really seen too many instances where joint ventures were either created in the digital space or involved even more low-level entities or startups that had received some funding but were not large enough to qualify themselves as business houses. So what I would like to propose to this group here and to whoever who may be interested in talking about this in the future is that I personally believe that for mature startups in India and for startups that are based in the digital economy, joint ventures where they can collaborate or where they can work together and where they can exchange resources could well be an alternative as compared to the classical way of raising funding through a Series B or a Series C round. The Indian startup funding ecosystem has now reached a stage where several startups have either grown beyond recognition because of the correct steps that they took, but several have failed simply because they either didn't see eye to eye with their investors, or their business idea wasn't good enough, or circumstances changed. So it is my intention to very briefly take you through what is essentially a classic M&A vehicle, which is a joint venture, and try and disrupt it and make it modern and make it relevant for today's digital economy. A joint venture, as you all know, is essentially a coming together of two discrete individuals, two discrete entities to create either something new or to create synergies and cohesion. You can have two forms of joint ventures. One is through a legally incorporated entity, where company A and company B create company C, wherein they both have shareholding. Of course, unincorporated JVs, which were, by the way, in the 90s and the early 2000s, a very good way of doing business. They've largely gone away now, for the simple reason that India's regulations have become such that, let's say you're creating an unincorporated JV, getting FDI into that business is going to be tricky. But I'll explain as I go along in the presentation how, for domestic startups, creating an unincorporated JV could very well be a useful tool for them to expand their business. Now, I don't want to get into details of the pros and cons of incorporated or unincorporated JVs. And for anybody who wants the details, you can pick up the slides from the organizers. But the essence is this. An incorporated JV requires a financial commitment or other tangible commitment into a third entity. The biggest advantage of doing that, of course, is that you're creating a separate business entity which in and of itself could well be a startup. So you could have a situation tomorrow where instead of receiving funding in your own entity, if your joint venture is doing well, you could use that entity to raise funds in the future. On the other hand, for an unincorporated JV or a contractual JV, what you have to understand is that this isn't simply a business partnership. So let's say you're a startup that manufactures, I don't know, water bottles. You're not entering into a contract with a mineral water bottling company, which is simply going to create your product for you. That's just a contractual arrangement with a supplier. This is an arrangement where the two of you have come together for an idea, which idea you ultimately want to implement as a separate business vertical. So you need to think of it as if you are that bottle manufacturer, but you want to get into chairs. Now you have, for example, 10 acres of land in Vizag. Out of that 10 acres, 4 or 5 acres is being used for your bottling plant. Now, instead of expanding that bottling plant, which may not be a very viable business idea, you could utilize that land and create an unincorporated JV where manufacturing expertise for chairs could be utilized. This is just an example. The point I'm making is that, and as a firm and as lawyers at our firm, we talk to startup founders on literally a daily basis. And their focus almost always, unfortunately, seems to be valuation and fundraise. So every conversation is around, okay, where is my valuation headed? Where is my next fundraise going to come from? To what extent will I have to dilute? These are all standard questions which any valuing entity, any PE house can answer these days. But if you go out there and do something different, if you go out there and say that, I have created this contractual joint venture, wherein I'm just taking examples here. Let's say we're looking at Jimmy's Cocktails is one of our clients. We look at Jimmy's Cocktails. Another client of ours is EM3 Agri Services. On the face of it, they're both very different startups. One is engaged in the agricultural services sector. The other is a beverages brand. But if Jimmy's Cocktails uses EM3's logistics networks across the country, where they have deployed their services through rural tier 2, tier 3 cities, that is a collaboration that both entities would not have thought about. So the limited point I'm making is that if you're a startup, especially in the digital economy, your focus should not only be around raising funds or increasing your valuation. You need to think laterally, you need to think out of the box and figure out which sort of joint venture would work for you. To summarize, the key issues that you need to think about is that, of course, you need to identify the right JV partner, right? A joint venture is pretty much like any relationship. You have to bear with each other, stick with each other. The advantage of, for example, doing a joint venture as opposed to receiving funding is that you retain control over your own entity. You do not have an investor sitting on top of you who, for example, has another investment in a competing business and is now pushing you to merge. Those sort of scenarios can be avoided if you try and create joint ventures of the type that I'm talking about. I also wanted to spend a couple of minutes to just briefly explain that joint ventures can be of multiple types. So, for example, one will be between two entities that are sort of equally placed. Not from the startup domain, but the Tata Starbucks example comes to mind. In India, Starbucks was a non-entity until they created that joint venture and are now pretty much prevalent across every tier 1 city. They are the premium go-to coffee brand in the country as far as people above a certain income group are concerned. That joint venture has multiple elements to it. It will have a supply chain, it will have a distributor chain, it will have inputs coming in from overseas. The Tatas will provide inputs from their other businesses. So as an example, we work with a Tata Consumer as well. And there, the synergy that they've achieved as a result of their own expertise in the consumer space is unparalleled. So if you are now a startup, and if you partner up with, let's say, a large business house, of course you are unequally placed. You are a startup with a product or a startup with an idea, but you're not necessarily big enough to leverage an equal negotiating or bargaining position. So what are the key aspects that you need to think about there? If you are a beverage brand, and if you're looking to do a joint venture with a retail chain, for example, Reliance or Spencer's, the biggest advantage that you would get out of the joint venture is the ability to scale. You'd be able to distribute your products throughout the retail chain. You'll be able to learn from their experiences of what sort of products sell more and what sell less. So while there is clearly an imbalance, that joint venture will allow you to grow your business far faster than would perhaps a fundraise of not a very significant amount. Finally, and this one is the one that I'm very keen and interested in, is that there doesn't seem to be really, if you look at the Indian digital market, the Indian startup market these days, and when we were working with our team and preparing this presentation, we were hard pressed to come across examples of pure joint ventures between two startups in India. They seem to be very rare. Perhaps the reason for that is that the focus so far has been on raising money and just growing it on your own. But step back and think of it really. Whenever that startup would have started out, unless it's a sole founder, it would typically be 2 or 3 individuals who would come together and create that startup. Those individuals are essentially creating a classic joint venture. So if I was, for example, the head of sales in a large company, and I decided to create a startup with somebody who was an engineer in that company, I have essentially created what is the classic JV. So when your genesis as a startup is the coming together of minds or the coming together of individuals, I fail to see how you can't take that a step further and start creating joint ventures between two startups. There are significant advantages of doing that, and I believe that this is the next disruption in our startup story that we will, or I hope to see in the next few years. When I talk to my clients or when I talk to my startup founders, I push them to also think about this disruption. Because the moment you create something like that, think of it this way. If you are startup A who is doing reasonably well, if you're startup B who is also doing reasonably well, let's say you create a joint venture that does really well, you could potentially invite funding into all 3 entities at the same time. It's like adding a whole new business vertical without really having to build it from scratch again. So that disruption is what I think is going to be really relevant. Of course, there are always demerits to some things. The biggest problem that I see, and I see this in most startups these days, is an ongoing commitment issue. The startups that you've seen fail in the past have typically been those where one or more founders have had to walk away for one or the other reason. Now, a joint venture, that problem is quadrupled, right? Because you have the potential of people walking away in the other startup as well. Also, I think the key aspect is going to be, going forward from a digital economy perspective, is privacy and data sharing. India's data regime is still archaic, unfortunately. And one is hopeful that in the future, the new regulations that are finally implemented will provide clarity. But that is one aspect that I feel because startups will not have a mature system behind them. There is greater possibility of leakage of data and information. Finally, circling back to the classic JV, some of us here who had started their careers 20 years or more ago and would have done some joint ventures in their lives would realize that the documentation is still the same. You still have to do an MOU, you still have to do a shareholders agreement, your charter documents need to reflect the joint venture arrangement accurately. You'll need to have technology transfer, you need to have IP protection. So the tools are still the same. And this is, I think, is the tenet of most disruption, right? The tools with which you cause the disruption are still the same. It's just where you focus them and how you channelize them that will result in the next big disruption in our startup world. That's all from me. Thank you.
Thank you, Sujoy. That was very informative and an interesting alternative to the M&A ecosystem. You have very eruditely and succinctly explained a joint venture as an alternative form of two or maybe multiple businesses combining their resources towards a common objective. And it's interesting because there is a lot of leverage for structuring, or there can be a bespoke arrangement rather than just it's a form of a M&A sort of a thing. So yes, thanks, and I'm sure our audience would have been greatly benefited by this presentation, and along with that some data regarding your advice and your views on the startups. So joint ventures can be a good alternative for alternate financing and combining the resources for the startups. But certainly, it's certainly a bespoke arrangement, which has been, the initial FDI, most of the FDI in India were also structured through the joint ventures. Best price, what was it? Walmart, yeah. So some of the major ones were joint ventures. So I'm sure our audience will have interesting questions for the panelists, and we'll take them towards the end. So with this, now I would like to invite Mr. Ashish Agarwal, who is the director of the Resurgent India, and he is an investment banker. So he will throw his insights into the investment banking scenario and the funding methods in the M&A sector.
Yeah, good afternoon to everybody. Thank you, Dr. Garg, for giving me this opportunity. And I would like to thank you to ASSOCHAM also for inviting me on such an important topic where we are discussing M&A in the digital era, actually. So friends, we are investment banker, and you know that in any M&A deal, the funding is the key. Actually, without funding, no deal can be completed, actually. So, and if you see from funding point of view, every deal is customized. In every M&A deal, the funding requirement will be in a different manner. There will be the different channel of funding. So we cannot say there is a standard process for funding or a standard way of raising funding for any M&A deal. So I think I'll discuss what are the ways of raising funding for any M&A deal. So if you see during COVID time, and because we are investment banker, we are regularly meeting with the different corporates and the different sectors. So during COVID times, what we were seeing, everybody was discussing that we want to exit, we want to sell our business, we want to, they were not very much optimistic about the business. But now if you see in the current scenario, when we are meeting with the corporates, every second corporate is looking to buy out some business, whether in the same line of business, whether they want to grow further in the same line of business, by way of inorganic growth, or they are looking to diversify also. So India is such a country where I think a lot of people or a lot of corporates are looking to invest money in India from the different part of country. And even the Indian companies are going global. So a lot of deals are also happening where the Indian companies are taking over businesses outside India. But if we see the numbers, last year numbers in 2021, the more deals were happened in the domestic markets. So out of the total volume, the 65% value deals were happening in the domestic market. So domestic market is also a big number in the M&A deal in the country. If I just want to ask from you, do you know that how many deals have happened in the last year, in 2021 in India? Total deals. Any ballpark figure, any number is in your mind? If you can just throw the number. Anybody, any number is in your mind? All of us are into M&A business or maybe helping M&As. Any ballpark figure, whatever the number is coming in your mind. Okay. Anybody can guess other number? Okay. So, total 2,000 deals were happened in the overall private equity and M&A market. Roughly 2,000 deals were there in the Indian market actually. Out of that, 800 deals were there, 806 deals were there in the M&A. So we are talking about the large M&A deals actually. There are many deals are there which are into mid-market and the small side deals also, which we are not noticing. Because what is happening, we are seeing that Tata has acquired this one, or the other Mahindra has acquired this one. But there are many deals which are happening actually, which we are not aware actually. So what we are thinking that we want to reach, I think this something around $30 trillion economy by 2047. The M&A will play a very, very important role actually. For that, the funding is, I think, primary source which is required. So friends, there are 3-4 ways of raising funding for the M&A. So in the current scenario, if you see, many deals are happening which are all equity deals. So if you see the one company which is acquiring, they are asking the other company to take the shares of that company so that there will not be cash outflow. This is the best way of, I think, in case of the M&A where you are not required to take any funding from outside. But there are many challenges in that case also. So we were doing one deal where we got one listed company which was acquiring the unlisted company. So there was a difference in the opinion that the listed company was saying that my share price is fixed because of listing market actually. But whenever we will value you less than that actually. So the deal could not happen actually. So there will be the challenges when we are talking about the all equity deals. These kind of challenges will be there. Then the another challenge is there. We should keep always in mind that there should be a covenant when all equity deal is there. The other party should not sell the shares within a certain period because you are a listed company. Suppose you are giving the good part or a good number of the shares to the other party in the case of M&A, they should have some lock-in period because otherwise what will happen? Your share price will tank actually. So these are some issues which we need to keep in mind when any all equity deals are doing in the M&A market. And but it is a good thing where you are not giving any cash or there is no cash outflow from your pocket that will help you to grow your business without putting money directly in the company. Another way of doing it, the cash accruals, whatever the profits or cash accruals are there, which you are using for the M&A transaction, then again there is no challenge because you are not going to any outside agency for raising funds. So that's a best way or best scenario. But generally what I have seen, people are not doing all accrual or cash the deal which are doing from their own money actually. Always they are looking, whenever any corporate is doing any M&A, they're always looking to leverage that basically from their balance sheet so that they can raise money from the market. So, so all accrual or all cash, all profit deals, there is no challenge. But when we are looking to take money from outside for any deals actually, so there are two ways of raising it actually, two ways of raising money, either debt or equity. So if you see the debt is having their own challenges actually. In India, the major challenge is that if you are doing a domestic M&A or domestic buying any company on the domestic market, then the banks are not allowed, Indian banks are not allowed to give you money for the buying out of the company. It can be, you can buy out the assets, but you cannot buy out the company. In that case, the banks are ineligible to give you money for this basically. So this is, I think, if you are buying out the company outside India, then you are eligible for taking the funding from the banks in the form of debt. But in the Indian market, it is not allowed. I think from the ASSOCHAM point of view, I'll recommend or I'll suggest that this issue should be taken up with the relevant authorities
which can help to the Indian domestic market companies, because out of the total volume in the M&A market, 65% were in the domestic market in the last year. So this will help, because banks are having a lot of money, but this money cannot go to these kind of transactions. So in case of debt, there are banks, they have their own limitation. When you will go to any bank for raising money against your M&A transaction, they have a lot of covenants, they ask collaterals, they ask personal guarantees, then they don't have the appetite to give you the long-term money actually. In India, if you go for any M&A transaction, they'll give 5-7 years max, they'll consider it basically. So we have to see that whenever we are going for any M&A transaction, which can be, who can be the partner with you for the debt raising. But other than the, banks, there are many credit funds have come in the country actually in the form of AIF. And they have raised a lot of money, and they are not bound to follow the RBI guidelines which are required to follow by the banks actually. So this is a good tool. They have a lot of money, they have a lot of dry powder to invest in these transactions. Although the challenge is that whenever they are investing or they are taking any exposure in the transaction, their cost is high. So if you compare with the bank and the credit funds, there is a difference in the cost, maybe something around, I'll say, from 2% to 7% kind of difference will be there. But it makes sense because the time is an essence actually. Whenever you are doing any deal, and if you get money on the right time and you can crack the deal faster, that will help you to grab that deal actually. So that's the another way of raising money through the debt in case of any M&A transaction. And the third way is the private equity. You see in India, still people are not very much keen to dilute more than 50%. They're always looking that there should be a less dilution. But in the other part of the world, if you see, there is no emotional or no sentiments are involved with the business actually. When they are reaching to a certain stage, they are looking that some bigger partners should come and they should take this business to next stage actually. In India, this is a challenge. So there are a lot of private equity buyout funds are there, but still they are struggling because they are not getting sufficient deals in India where they can do the complete buyout and they can help these entrepreneurs to come out with this situation. But even the private equity has its own challenges also. They have their limitation of their timelines, because whenever we are taking money from any private equity fund, we should always see what is the remaining life of the fund. Many times they are doing the deal at the last leg of the fund, then they will change you to go for IPO or they'll change you to do this follow-on round or secondary. Otherwise, this will be a problem to you that after 2-3 years, you have to find out the another investor, and it might be a big challenge for you basically. So this is another aspect we should keep in mind, and their return expectations are always high actually. So this is always, I think the debt is always cheaper. Equity is always costly actually. People think that equity is cheaper, but in the nutshell, if you go, the equity is always costly actually. So this thing we should keep in mind also. So from my point of view, I think these are some of the highlights or the areas which we need to keep in mind whenever we are going for any funding for M&A. But you see in the current scenario in India after IBC, a lot of distressed deals are also coming actually. So there is a separate category of the funds. Those are specialized funds. And these are very large fund actually. They have raised fund. They are looking such kind of deals where they can invest in the distress kind of situation. Although we have seen that in the IBC, the top 15-20 deals which were happened some year back, which were highlighted. But there are many deals which are pending in the IBC process, which can be, I think, solved or which can be, I think, resolved by way of the specialized fund. They are ready to fund the deal. Subject to that, they should get the right valuation of that. So thank you very much. If you have any question, I will be happy to take it. Thank you.
Thank you, Mr. Agarwal, for that valuable insight, and I'm sure our audience would have been benefited from this primer on the investment banking and funding opportunities for the M&A transactions. We'll certainly have this questions. We'll wait for the other presenters to present, but I'll certainly want to ask you a question regarding your experiences with the funding of in the digital economy. Some digital transactions or maybe some particular aspects you might have faced. So now I would want to invite Mr. Abdul Rashid. Mr. Rashid is FCS, FIPM, and is a practicing chartered secretary, and is also a former council member of the Institute of Chartered Secretaries of Bangladesh. So Mr. Rashid will provide an insight in the economic situation at Bangladesh and investment and business opportunities. Over to you, Mr.
Panel moderator, Dr. Ishamji, panelists, Sujay Bhatia ji, Ashish Agarwal ji on the dais, and Advocate Venkat Rao ji attending online, and all the delegates, participants, and organizers of the dais. Very good afternoon. Good afternoon, everybody. Since I am from Bangladesh, I am asked to discuss about Bangladesh economy in the context of M&A joint ventures and this issue. You know, Bangladesh is a least developed country aspiring to be developing country by 2026. Its economy is based on agriculture, besides some sectors like garments and leather products for exports. For the issues related to M&A, we experienced recent M&A deals like acquisition of Sanofi Aventis. Their plants in Bangladesh were acquired by Beximco Pharmaceuticals. Another acquisition of 82% of stake in GlaxoSmithKline in Dhaka, in Bangladesh by Radiant Pharmaceuticals. Acquisition of controlling interest in Apollo Hospitals in Dhaka by Evercare and CDC Group. Another acquisition of 65 megawatt solar park from Singapore-based SHC Holding by China Hudians. You know, Bangladesh is one of the best investment destinations in the world because of low-cost labor in Bangladesh, large population, that means large domestic markets. It has a strategic location, high profitability, demographic dividend, attractive incentive policies in Bangladesh from the government, consistent reforms for better business climate, reserves of natural resources like gas, political stability, easy communication, and good exchange rate. If I summarize, foreign investors may come to Bangladesh for continuously rapid growth seen in Bangladesh, strategic location, young and skilled workforce, growing population, competitive labor costs, openness to foreign investment, and trade agreements. Another important influencing issue in Bangladesh is increasing number of internet users. The government of Bangladesh has introduced one-stop service for the investors under Bangladesh Investment Development Authority, BIDA, as a single window and the only point of contact, only on point of contact between the investment-related services operating outside special economic zones like BEJA, Bangladesh Export Zones Authority, Bangladesh Export Processing Zones Authority, and Bangladesh High-Tech Power Authority, and has been implementing a project to establish national single window under National Board of Revenue of Bangladesh, NBR, in order to improve conditions for reducing logistics bottlenecks and supporting the adoption of modern approaches to broader border management and trade facilitation. What are the potential investment sectors in Bangladesh? As emphasized by Bangladesh government, the potential investment sectors are agribusinesses, cold storage facilities, cultivation of seeds, eco-friendly jute products, shrimp farming, fertilizers, electronics, garments and textiles, ICT and business services, leather and leather products, light engineering, power industry, and life sciences. So what are the methods of foreign direct investment in Bangladesh? Like your country, acquiring voting interest in foreign company, mergers and acquisitions, joint ventures, starting subsidiary company, or starting new business. But there are some restrictions on freight forwarding business, logistical services, banking and insurance. However, under special consideration by the government of Bangladesh, LIC India has opened a subsidiary company in Bangladesh in the name of LIC, Life Insurance Corporation, LIC of Bangladesh Limited. Another important investment of India in 50-50 joint venture between NTPC Limited and Bangladesh Power Development Board for Bangladesh India Friendship Power Company Private Limited. Fortunately, I had been the consultant from the very beginning for NTPC joint venture, and also I have been supporting the LIC company, LIC Bangladesh, since 2015. Like the practice of your company, most common wage of acquisition in Bangladesh is acquisition of shares through transfer of existing shares or issue of shares, merger, demerger, slump sale, acquisition of assets, and joint ventures. There are some advantages and disadvantages in each way, like your company, in terms of initial costs, time to conclude the transaction, formalities, tax effects, manpower of the entity, implementation, etc. And you know, the common factors influencing merger and acquisition in Bangladesh also are increased competition, technological development, modernization, restructuring of production, change in strategy, etc. In times of disruption, in times of transformation, in times of digital economy also. May be required for vertical integration, may be for horizontal integration or expansion or extension. But common considerable issues are, like every country, exclusivity agreement, non-disclosure agreement, due diligence, corporate approval, shareholder approval, contractual consents, regulatory approval, signing and closing, communications, negotiations, costs, payments, etc. And finally, post-closing formalities. I think you will have some insights from my discussion. Thank you for patient hearing.
Thank you, Mr. Rashid, for that very interesting and insightful discussion upon the economic situation in Bangladesh regarding business opportunities for the Indian business in Bangladesh, and also I'm sure you will find in India opportunities, what opportunities the business or investors from Bangladesh might be looking for. I'm sure our participants will have questions, but we'll wait towards the end of the session. With now, I will invite our last panelist, Advocate Venkat Rao. He is the founder and managing partner of Integrat Law Offices. Over to you, Mr. Venkat Rao. Mr. Venkat Rao will be joining and addressing through virtual mode.
Thank you, Rishamji. Mr. Bhatia, Mr. Ashish, and Mr. Rashid. It's been a wonderful session so far, and I have been tasked with the most difficult task of being the last speaker in the last part of the session and holding back my wonderful delegates from that network and tea, and holding back them from their tea and cookies is definitely putting some misery on them. So I would, being in the business of seeking justice, would try to put their misery to end as quickly as possible. And having said that, I am again sort of could not make it personally there. I would have it would have been great. But though considering the fact that this is on the digital economy and electronic connectivity and is one important aspect in entire digital economy, so I'm good to be there on with you. While speaking on digital economy and the M&A, I've been tasked specifically to touch base on one subject that is most interesting and important and close to my heart, that is real estate sector. So naturally, I would sort of come back and focus on it. Ashish Shetty is sitting in dais, certainly smiling yet. He would say that he would never forget about real estate. So having said that, I would like to say, look, time has not only circled around the clock, but evolved over the times through emulating technology like was in prevailing times. Everything is accessible at a double click for every person manifesting a connection with the world at large. Definitely, Mr. Sujay and Mr. Rashid have already touched based upon the legal aspects, and Mr. Ashish has already touched based upon the entire investment side of the digital economy. I would rather be more generic and try to touch base upon the challenges that were there before digital economy was in place, or the double-click connectivity was in place. So I would say one big thing that has opened up is the entire global opportunities that are available, because we being internet has changed it, and we being connected through, I always say it is through screen. Now, human-to-human interaction probably is lesser, and therefore I believe that me being on the screen would have more attention rather than being physically there. Having said that, one thing for sure is that now the way the things are changing, whether be it in M&A or whether be it in setting up of new ventures in different parts of the world by industry, is one big thing that is happening. And probably we have heard through the other dignitaries the kind of investments that are flowing into this country. I would say immediately one thing that comes to my mind is the recent acquisition of an Australian portal by a RIA group, which is Singapore-based property group. If you look at the markets that have widened because of the reach of the digital economy, is such that they would want to market their products, which they are able to access from the different parts of the world onto the world at large. Now, that's one aspect probably has opened up the industry and is giving more opportunities. Having said that, over the period, we have seen that prior to digitalization, even otherwise also in the past before the much opening of the economy, we've seen that they've been for an M&A, especially if I talk of real estate again, we would find that it was a cumbersome process. Even within the country, forget about global acquisitions or global investments into this country. What we used to see is that real estate had always been a local and limited, region-based industry. We would find that local players were more stronger. The reach of the developers was also much limited. And of course, the regulatory framework also did not help. But with the changing technology, the probably emerging, more and more digitalization, what one finds is the simplification even in the regulatory framework. I would remember at one stage coming out with even notices to the stakeholders used to be typically through a physical form. Today, for M&A acquisition or anything like that, you could actually digitally send it and comply with the regulatory requirements. So it's as basic as that which has emerged, which is changing the scenario of M&A and even setting up ventures in the country. Having said that, another aspect that, of course, which has opened up is as I said, we were not accessible to artificial intelligence. The mechanism of availability of your product or showcasing your business to the world at large was limited. Today, due to accessibility, the global reach has substantially increased, and thereby I would say that marketing companies with particularly resorted to traditional methods of promoting were subjected to venture for the purpose of spreading insight of a real estate project. So these things have changed. Today, we have a much larger reach and much larger communication. I would say, looking at the overall aspect of the payment mechanism, the showcasing of the projects within the to the furthermost, probably a person sitting in US could actually look at what kind of a product a particular company is able to offer, would be in a position to inquire and then invest. That actually is increasing the value of a particular company, thereby bringing in not only the opportunity of further investment, but maybe bringing in larger players into the country for maybe acquisitions or entering into joint ventures. So, yes, if you typically talk of certain industries and still the regulatory framework being still as what it is, we may not have reached a certain stage where it is much faster. Still, for instance, in the property transactions, we still would look to have physical presence for execution of the deeds and so on and so forth. So therefore, we still may require furthermore probably changes in the regulatory framework and the laws. But yes, the payments, the commitments, the reach has substantially increased, and the markets and the valuations of the even the local players have certainly gone up. Having said that, in the recent times, we see that, for example, DLF Cyber City Developers has just entered into a joint venture a couple of years ago with the Singapore Sovereign Wealth Fund, GSE. Well, these things will encourage a further, a local player to reach out and probably, showcase his products across and, increase the values. In the same fashion, yes, there are restrictions of FDI being in this country into real estate. There are monitoring mechanisms which certainly have to be there. But to the extent that we were there a few years ago and today, certainly there is a huge change. Lastly, I would say, of course, the technology, as I said, and as I said, I would be very quick in putting an end to the misery of, and I won't hold you back for long. I would like to thank ASSOCHAM and its team for having me digitally. I'm sorry I could not make it personally there, and probably my old friend and me would have, Ashish would have discussed on how much of hair we would have lost during the last few months that we have not met. But I'm thankful to all of you. Thank you so much.
Thank you, Mr. Venkat, for your interesting and very. As a lawyer, we understand the first thing is brevity. So this was this was quite to the point. Before I open the floor to the questions from the audience, I would like to continue with Mr. Venkat Rao, and as he touched upon the aspect of real estate and financing and the area of real estate. What comments would you have on these REITs as an investment vehicle, and what is your experience in this sort of a financing? How is it going to be helpful, or on ground reality? Is it actually successful in volumes, or there are only one or two occasional deals?
Well, Rishimji, unfortunately, the markets in real estate have actually started probably getting educated about REITs and its usage maybe last 5 years or so. And if you look at the industry also, it has also gone, seen all kinds of roller coaster ride, and if you see the recent trend of past maybe 3 years or so, things have started changing and improving in the real estate industry. While REITs is an excellent vehicle, I mean, unfortunately, we see that companies directly offer various kinds of, investment options to people at large. But that, in fact, is, fraught with risk, and I'm not going to go into the regulatory violations thereof. But rather than that, REITs is a great opportunity. And yes, as you have rightly pointed out, it still is a very selective, because REITs actually assures a certain percentage of return to the investors, and it has to have income yielding asset in it. So therefore, there is a limitation there. But I would believe that more and more awareness and investors consciously, today we see that only high net worth investors getting in, but maybe more of awareness, we would have much more matured REITs market than what we have today.
Thank you, Mr. Rao. So now the floor is open to the audience for questions. I hope that we will have some volunteers for the question. So in the meantime, what we can also do is, if you can, set up my presentation. In the last 2 pages, there are some questions. We could, throw some of those questions to the participants, to our panelists. And again, I will ask Mr. Santosh, how much time do we have left? Okay, so I am sure we are good here. Yeah.
How to analyze so many digital transactions? How many? Hello. How to analyze so many digital transactions? Previous times, tradition times, there were so many cash transactions. So it was cash, no incoming, no outgoing. Now with digital transactions coming, there are so many digital transactions. So how to analyze? Who will analyze? How to analyze?
Yeah, so I think our investment...
This is question number 1. And question number 2 is, we see that when government sells some offices means some industries like sugar mills or this airline, people say that Tatas are purchasing at a very cheaper price. So it should be a win-win situation for both the parties, government as well as buyer and seller. It should be a win-win situation. But we hear, I don't know, that some gain more, some loses. And number 3, what is the impact after the merger has been done? Means what is...
Right. So very interesting, I think, for our investment expert, Mr. Ashish. First 2 questions, and the third one for Mr. Bhatia.
Yeah, I think The second question first, regarding this, whether the deal has been, or the transaction has been sold out at the low rates or the low cost and all, basically. Practically, whenever we are commenting on any transaction, we have to see the detail of the transaction actually. So whether you have given the example of Tata, so Tata deal, there were many considerations which were there in the deal, and if you go in the detail, no assets have been transferred to the Tata actually. And I think government has got this very good deal actually, practically if you see from that point of view. The loss-making organization, which was, I think the government was incurring thousands of crores every year on that kind of organization. It can be saved for this is public money actually, which can be saved for the other infrastructure projects and all basically. So I think for any amended deal, there are many things are there which need to be seen in detail. Then I think we should be in a position to know that what are the areas where this has been sold out at a low cost or it's a reasonable cost actually. So that's the one thing. I think digital transaction and the physical transaction, the cash transaction, I could not understand your question actually. Digital, this UPI you are saying, or what you are saying basically? Digital, what your meaning actually? What do you want to know?
So there are so many transactions digitally. How means government departments, when they check through GST and likewise import, export, so there are digital transactions. So obviously digital transactions are in picture now. Nobody is doing cash transactions. So how they will evaluate? Because in the previous meeting they said that traditional we are very accustomed to, but now with the modernization and digital transactions and with digital marketing, digital economy, we are unable to handle it out. Means the process or remedies or likewise.
So you are saying, I think very clear in the digital transaction you have complete trail. Everything is in the system actually. So I think in case of digital transaction, you are in a better position to know that when this transaction was happened, how it has happened and all.
I have a clue actually. We transfer through current account into another party's current account. GST bill is raised, the deal is clear. Sometimes it happens out to be that people transfer from saving account, correct? And GST bill is still being raised. So this is a loophole.
Okay, so these are some, I think, examples or maybe the specific areas which need to be taken care. I think because when the economy is moving from this cash to digital, these things will come. I think government is trying to plug in all these things as and when it is coming in the notice of the government. So I think my panel speaker can also comment on that if you have anything.
Yeah, I mean, the only thing I would add is that when the government disinvests any assets or shares of any company, so if you just look at, for example, the website of the Department of Disinvestment, the front page has a clear-cut guideline on how every disinvestment must take place in terms of a public information memorandum that goes out, invitation of bids, then a confidential information memorandum, and so on and so forth. So each step, each value is publicly available, and every transaction, by the way, is also revalidated by the CAG. So there is, even if there is a perception that goods may or assets may have been undersold, in my experience, and I've actually been working with DIPAM for 10 years now almost every transaction where the government has sold, so Air India or a few others in the past, the transactions have been such where the government has actually got a very good deal in terms of what it was selling. Because what people don't understand is that the government doesn't negotiate really. When you're doing a private M&A, the amount of negotiation that happens on the commercials is much higher than on the document. Whereas when the government is selling assets, the government has just put it forward saying this is what it is, take it or leave it. And the government's only doing it to maximize its own revenue and return. So I think most of the deals that the government has struck so far in the past few years, and Air India is a classic example of letting go of significant losses. The government has gotten a pretty good deal, and I think that will be the trend going forward as well.
So it means misconception flourishes. It means sometimes what we hear newspaper and people say, it is a misconception or miscommunication.
Yes, absolutely. And in fact, people who are in this room and who are, professionals should be able to analyze the deal themselves. The deal information is available, and if you just look at the numbers, you'll be able to figure out that it's not a bad deal for the government.
Sir, I have a question, and may I request this question to be directed to, this can be passed on to Venkat Rao, sir. Sir, I am Santosh Para, sir. I would request for your kind attention on one question which pertains to your real estate sector. Though we had the Honorable Prime Minister's, housing for all, the timelines 2022, we've seen that how it worked, and now we are seeing that there is ease of living for vision 2047. So it looks like housing for all is done, and now we are going to talk that ease of living within those houses to be envisioned like that. So how do you take that the real estate sector, whether since you are being very closely managing the affairs and then doing all such regulatory compliances, all that such matters, how do you see that this gap is there, anything like that in the housing for all as well as ease of living vision? What is that all, and how the merger and acquisition in the real estate sector can be of some supportive to it, that really can do a lot more what is actually required for housing for all, to my understanding? And is there any requirement wherein industry chamber like ASSOCHAM can contribute towards putting forth the ideas what is required for the real estate sector so far the merger acquisition is concerned?
Thank you, Santoshji. I mean, for suggesting that real estate industry is my industry or sector is mine, and I just, I mean, it's something that I would be proud of to be. So, having said that, now housing for all has definitely not the idea when it is said that ease of living is going to be the next target. It does not mean that housing for all has ended. No, it's not at all. Two things are for sure. There is an effort on the part of Honorable Prime Minister and definitely the government is to focus as to improve on the living conditions that are there, which not only relate to mere housing, but also to the entire infrastructure, including environment, so on and so forth. So when it is ease of living, that's one part that we are looking at, which is much larger. Now, having talking of housing for all, now we know that we have not reached there, and there is much to be achieved yet. And the numbers, of course, speak for themselves. We have not even probably at the from the percentage levels, if we look at it, even at the 40% of what we had thought of to achieve when we started off. But definitely, there is a focused approach towards it. Now, having said that, what could be the how an M&A and JVs would help? Now, if you look at it, most of the investments that have been flowing into from the overseas have been into little luxury and high-end real estate, which has a lot of margins, still continues to be there. But somewhere along the lane, we need to look at it that maybe a low margin, high volume game of affordable, which in certain segments and especially south of India, I see that there have been some players who are specifically focused on it, and there have been some overseas investments that have come into, but which need to be probably promoted. Therein, much more probably leeway and liberalization is required. That could be a place where even the industry should push for in terms of much more liberalization needed, even in terms of maybe offering some special incentives beyond what it is there today, would actually encourage investment into that segment. Because it is a low end, low margin, and at times challenge of financing is a big challenge in that segment. Maybe we should look at encouraging, bringing in large investments into that sector, that segment of the sector.
So then I may come back to you with all the requests from this particular council and ASSOCHAM side to guide us that what is the roadmap that we propose in alignment of the Vision 2047 that Honorable Prime Minister is aiming towards the ease of living. So please guide us that what is your idea on around the roadmap which can be aligned and integrated to the envisioned idea of Honorable Prime Minister.
It would be an honor and.
Surely, sir. Thank you. My question at rest.
There's one question there.
So my question is to Mr. Venkat Rao. How much you think the IBC code is effective in real estate deals where the builders have, gone rogue or and the construction is halted? How the RP can be so effective in taking over such cases and handling it?
Well, I think I touched a very sensitive industry, whereas this entire session has been on MIS and across the board on all industries. But somehow we've
been discussing IBC since morning, so.
So yes, the challenges in IBC, especially in resolution side of it, have been great. Unfortunately, real estate and resolution to real estate projects is not an easy task. Unlike in case of other industries, the stakeholders in this is directly probably a man on the street. So his grievance would be much larger. Having said that, the structured deals that have happened in the real estate have also greatly contributed to this delay. I mean, there is no hiding the fact that hardly there have been maybe a minuscule percentage of resolutions that have happened. And we are looking at a lot of large companies which have gone into insolvency but have not been able to still find a solution onward. There's been a lot of debate, in fact, including the debate on project-wise resolution, so on and so forth. I, for a moment, have always felt that time has come where, whether be it IBC or whether be it RERA, one has to have a relocated from the entire perspective of real estate per se. And of course, especially in case of IBC, if we are talking of individual project-wise resolution, then maybe a steel manufacturer would say that, why not for me? So there also you need a detailed debate, and probably a stricter and much, stringent timelines need to be imposed for a resolution of even a real estate-based company.
Okay, so allow me to, supplement the views of Mr. Rao. So it's, I'll take a cue from what he just said towards the end. Yes, we have to understand that a sector's problems or issues needs to be addressed by that particular sector's, let's say, resolution mechanism, right? So the resolution mechanism for the real estate sector lies actually with the RERA. It's not with the IBC. And previously also, if you might remember, a few years back, maybe 4 or 5 years back, when the CACI had investigated this case against the DLF buildings, residential apartments in Gurgaon, Bel Air and one more. So this was basically, a builder-buyer agreement, and then they have to find out whether the case is within the jurisdiction of the CCI or not. And then they found out that yes, DLF satisfied that dominant category, and the case was could be made out against DLF, and a fine was also imposed. So these are stopgap arrangement that okay, there is no short remedy or mechanism available. So what is the category? What is the status of an individual who is investing in the real estate? Let's say a home buyer. So home buyer, what is the home buyer purchasing? They actually want to purchase for themselves, but they are also investors. And when they are investors, now IBC has provided them an opportunity of being a financial creditor, that's at par with a secured creditor. So there is some fault in the legal regime why were the home buyers or the individual investors not considered as a secured creditor? Because they have no interest, because the project is already mortgaged to the banks, and banks have the first charge. So banks become the secured lenders, and probably nothing is left, for the home buyers to also have a security. There is nothing in their contract that you will have a charge on that. So hence the IBC provided that change in that definition, that home buyers will be treated as financial creditors, similar to secured creditors. However, this is not the real solution. As far as the real estate issues under IBC are concerned, recently, the first enclared Honorable Chairperson Justice Mukhopadhyay, he conceived an innovation of reverse CIRP, where the builder itself was provided the opportunity of managing the process. So there have been some success, but it's mixed. It's some judicial innovation, but these are all probably not decided or certain arrangements which can continue. So yes, I'll say that this is a period of gestation, and there's a lot which can be said and a lot which needs to be done. Mr. Rao, as a legal expert, and me as a legal academic, my view is the same, that this for a particular sector, the resolution needs to be from that sector itself. So IBC will give the control to an independent resolution professional who will manage. But again, because of the dynamics of this sector, we have not seen that any resolution professional actually has independently managed real estate. If there is, I'm not aware about that.
And the customers keep on paying their EMIs, they don't have the asset in hand, and the process just continues.
Yeah, this is a problem actually. The individual, this individual may be a salaried person, right? So you are getting a salary. Then you have taken a housing loan. You are paying EMI, and you may be in a rented accommodation. You are paying your rent as well, and the real estate, you are paying them installments, and you don't have any charge or security. Because the Transfer of Property Act does not recognize a transfer of interest to this particular individual who is called as a home buyer. Yeah, this discussion, debate is unending, and yeah. So if anybody else wants to join in, I know there are some great legal experts, insolvency practitioners here. If someone else wants to have their views, most welcome.
Sure, I'll share a couple of views on this particular aspect, because I happen to work upon real estate and real estate oriented insolvencies quite extensively for that matter. So thank you for raising this particular subject, and having the audience of Mr. Rao is all the more attractive for me to share my views as well, sir. Particularly in the context of real estate insolvencies, while yes, there was a judgment which did say that reverse insolvency could be a solution, in the context of ensuring that the home buyers' interests could also be safeguarded while ensuring that the construction continues in that sense. Effectively, it is that one of the key solutions that we could see over here would be that of interim finance when it comes to corporate insolvency resolution processes, because that interim finance would be something that would enable the company to remain a going concern. Similarly, in Justice Mukhopadhyay's judgments, the one that you had mentioned pertaining to Winter Hills, effectively, therein it is that Mr. Mukhopadhyay has also very, interestingly mentioned that when a CIRP is supposed to be initiated against a real estate company, it's not the entire real estate company, but it is rather the real estate project that should be made the subject of CIRP. The technical challenges, however, that come about in that sort of a situation are how do you distinguish between a balance sheet on a project-to-project basis? It is not something that you can actually resolve, and that is the key technical reason why that particular idea has not taken off in the way that it could have. It had certain potential, but there were certain technical challenges that could not be resolved subsequently. Probably this is something that the IBBI could look into, maybe. The next aspect pertaining to the specific question about the plight of the home buyers who are paying EMIs without actually getting an apartment, and in addition to EMIs, they may also be paying rental expenditure as well in that context. So they are all the more burdened in this sense. To this effect, it is that there are certain litigations which are going on presently before the Delhi High Court, And
Yes.
Justice Rekha Palli had earlier this particular year in January and subsequently with various other orders in March and June as well, suggested that there would be a stay on various NBFCs, financial institutions, lending institutions from proceeding under SARFAISI against these particular home buyers in that context. So while the lending transaction also, but this again, like, stands in direct contravention or rather conflict with certain other jurisprudential principles that have come out of NCLAT and also which are pending consideration before the Supreme Court, because in such transactions, what happens is that who should qualify as a financial creditor and who should get a seat on the COC, whether it should be the lending institution or whether it should be the home buyer, again remains a debated issue. Various NCLTs have said it should be the home buyer, various other NCLTs have said it should be the financial institution. The NCLAT said it should be the home buyer in this particular context. And now, in one of the judgments pertaining to PNB Housing Bank Finance, it is that the Supreme Court has to finally take a call on this, but that particular matter has not gotten listed in the longest because of COVID and other reasons in that regard. So while that particular debate continues, I think the regulators could certainly pitch in over here, and I agree with the views of Mr. Garg and even with Mr. Rao as well, that effectively it is the regulator of that particular sector that should come in and try to resolve the issue in this particular regard. Thank you.
I personally feel the solution is only when the home is built, then give and then purchase. Matter solved.
Well,
I'm sure. So we have one legal expert, Ms. Pooja Mahajan, who is also leading insolvency lawyer. Let's hear her out on this issue.
Thoughts which have already been said here. Perhaps the right forum really to resolve the the real estate issues when it comes to home buyers is really RERA, according to me. It's a specialized forum for these matters. And again, just talking from personal experience in terms of what really can drive the builders to actually complete the project, I think anytime there are some criminal proceedings against them, that's when the action really starts. In all cases, I've rarely seen an IBC case succeed, except maybe perhaps one case, and that also after the approval, the matter has gotten stuck. And ultimately, it's the promoters who have either stepped in or the matters are just pending. So again, unless there is a drastic change in law coming out with a separate regime for IBC for these companies, as of now, I think IBC is not the right forum for it, and it's perhaps RERA is the right forum.
Just to add, if Shubji permits me to add a couple of things to what my friends have said here. One aspect that, the writs being filed before the Delhi High Court, in fact, mine is the lead matter in it, and yes, Justice Rekha Palli had taken a stand, but then if you look at it, it's a vicious circle. It's a chicken and egg, whether the financial institutions' funds which have been mobilized from various fixed deposit holders or so on and so forth, though, yes, good, bad, ugly, lent to a builder, have not come forth, and in these subvention schemes, right, wrong, whether at this stage they should be the sufferers is one aspect of it. The other aspect, as my friend has rightly pointed out, whether this project-wise resolution, I fail to understand as to why it has come to such a stage that there is a judicial experimentation to happen. Now, in a recent matter, one knows that there is a project-wise resolution which is called reverse insolvency. Is being tried or experimented. But then I know for a fact that there are many other home buyers who are, or even institutions for that matter, who are within that company having, exposure to other projects, are suffering in a sense that they say that, look, we do not have a recourse, we cannot go any further because there is a particular CRIP is not stayed, but there is a situation where moratorium continues and it's only for one particular project. We don't know whether that will go through or not, and why are we suffering? So it cannot, as my friend has rightly pointed out, cannot be picked up from the entire balance sheet of a particular company and try to find a resolution within the current code. So given that, I think a relook at both the acts, especially in case of real estate, need to be looked into. And if the premise, as one looks at analogy of being a real estate project, being a separate project and therefore need to be resolved separately. As I said in the beginning also, there could be a steel manufacturer or auto manufacturer who might have 10 manufacturing setups, and probably one manufacturing setup may not be doing well. He would also seek the same kind of resolution. So to that extent, you need it deliberated. It cannot be experimentation. I'm sorry to say with in the open forum, but it has to be a well deliberated amendment to the act, and probably then we may find a solution to it.
Thanks. I see that, this topic touched a raw nerve and it's, quite passionate. Let's, move on to some other topic, some other questions. And probably if there is, I'll probably take one question from my set of questions that have been curated. And let's take this question addressed to Mr. Bhatia on due diligence. How vital is for investors and M&A teams to be prepared in this era of disruption and transformation? Mention certain aspects to focus upon, and in due diligence, list the key considerations regarding due diligence, including deep customer and product diligence during the pre-signing.
Okay, so if I answer all of that, we'll probably be here till tomorrow. But jokes apart, I think some aspects of due diligence were covered in the morning as well, where the other speakers touched upon what is essential and what isn't. In my personal experience, the whole point of a due diligence is being diligent. You can't just do a diligence for the sake of it and just move forward. So if you have a 2-week timeline or a 2-month timeline or a 6-month timeline to do a deal, you either choose not to do a diligence and draft your transaction documents accordingly and seek the protections that you want from the sellers. Or if you choose to do a diligence, give your advisors the right amount of time, choose the right professionals. So don't expect the big fours or the equivalents of the big fours to try and run product diligence for you or even quasi-legal diligence. At the same time, don't expect a law firm to do a full-fledged tax diligence. So be diligent in the choice of your advisors, be diligent in the amount of time that you're giving them. And to my mind, and some members of my team are here, we're currently running a diligence where we're working with law firms across 6 jurisdictions. And what is happening is that in every jurisdiction, and this is the case with India as well, materiality can change. So pick the right materiality thresholds in terms of what is important for you in a standard diligence. Now coming to product and other specialized forms of diligence, I think it is well worth, and I think Samit sir in the morning was alluding to some examples where they appointed experts to go and look at stocks sitting in a warehouse, which while they'd received a certificate that it was all right, the stock in fact was rotten. So I think it's well worth spending the money to appoint specialists to do an environmental due diligence if you're doing a factory acquisition, or to do, for example, if you're acquiring an HR or an employee-heavy business. It is well worth doing a HR audit to figure out the culture of the business. On the other hand, if you're doing, for example, a acquisition in a digital economy space, I think compliance is, as far as the RBI is concerned, becomes relevant, especially if you're in the financial services business. So engaging in conversations with the regulator pre-doing the deal, I think is also not a bad idea. If you look at any of the regulators in India today, whether it's SEBI, RBI, IRDA, MCA, Disinvestment Department, they're all very modern. You'd be surprised that if you go and meet them, how cooperative and helpful they can be. And if you're looking at an acquisition, for example, in the regulated financial services sector, your conversations with the people who actually deal with entities will completely change your perspective on how you do the diligence. So my last suggestion would be, don't use it as a check in the box exercise. actually think about what matters for the business and implement accordingly.
Thank you. Thank you, Sujay. Now I'll ask, this I'm sure might have been asked, the question. So the first one, M&A activity was at a high in 2021, despite a disruptive 2020 due to the COVID-19 pandemic. And in 2022, global M&A slowed down due to the surging inflation, tougher regulation. So this is the backdrop. And now how important it is for potential acquirer companies to carefully consider macroeconomic, political, legal, regulatory developments as well as potential distressed M&A opportunities in their M&A strategy. So I will request views from Mr. Abdul Rashid and then from Mr. Ashish Agarwal.
Thank you for the question. When we deal with legal aspects and agreements and the activities like M&A, we shall have to consider all aspects related to economy, political aspects also, because if any decision is affected by political decision, then it should be avoided. Again, if we see that there is a possibility to happen a flood, then we shall have to avoid the activity of the business which is affected by flood. So, prospective developments in legal framework, if there is a possibility to have a change in the economy in any country, the legal framework is being changed. In that case, the initiator should wait for the change happen. If it is not waited, then there shall have been any type of disruption again for the investment, potential investment, I think.
Yeah, hello. I think you already covered that part actually. I'll just give you the example or maybe case study. So we were doing one transaction for an NBFC basically. So the challenge is that in case of any NBFC, more than 25% of the shareholding when you are doing a mandate transaction, you cannot sold out more than 25% of equity at a one go to any investor or any acquirer without RBI permission. So this is I think, big regulatory aspect. Whenever you are doing any such kind of deal, we have to see what is the regulation for that and how to protect your money. So there is the one way of doing it, because in many times, but we have seen the acquirer is willing to pay money for the 24% or 25% equity, but they want to protect their money also. So the better way that you should keep this money in the escrow account. You can have the kind of MOU or the agreement, but whenever the RBI approval will come, then the entire money. So you are showing your intent, you are getting into agreement, but practically you are not taking risk on your head. Otherwise, you will give this money to the seller, and sometime you are not getting the approval, then the money will stuck actually. It will be very difficult for you to get back this money actually. So I think this is one practical example which I like to highlight. There can be many other examples related to the sectors actually. Thank you.
We have a lot of long bit of questions, but we are also running out of time, and I believe we have had a very interesting and informative session. And in case there is no other questions, I would just like to ask my fellow panelists if they want, any one of them want to make any final comment before we finally conclude.
Thank you very much, Mr. Moderator, Dr. Risham Garg, Mr. Sujoy Bhatia, panelist Mr. Ashish Agarwal, Mr. S. Abdul Rashid, and Advocate Venkat Rao sir for making this session very, very useful, insightful, and wonderful for the audience over here. And I hope that this entire day has been fruitful for the enlightenment, learning, and enriching the know-how, knowledge on the subject for each one of us presenting over here. And further, if in case if you have any questions, or you may like to contribute to, or you may like to add on value to our councils, which are focusing on legal perspectives, legal domain, we welcome your support, contribution, participation in our future endeavor as well. And thank you so much to all the dignitaries on the dais. Look forward to your continued association, participation. Keep coming, sir. There is just an announcement regarding our one activity, that's the 7th International Conference on Competition Law that we are hosting on 15th of October at Hotel Hyatt Regency in New Delhi. We are in honorable chief guest. One is Dr. Sri Ashok Kumar Gupta ji. He is the CCI chairperson. He has already confirmed. We have invited Mr. Jain Sinha, who is the parliamentarian and heading the Committee of Competition Law in the Parliament. He has been invited. So we look forward to your participation, contribution in that program. And if you have any further inputs in that context, please, we invite and welcome your support in that. Thank you so much, all of you, to make this session a wonderful day for the closing of this session.
Thank you, fellow panelists, and thank you, the audience, for their patient hearing, and I am sure this was informative.
We are extremely thankful to all the support partners who joined and extended support for this program, starting from Gold Partner, Smart Bharat, Resurgent India, JSW, SMC Global, Institution Partner, ICSI, Associate Partner, RRG and Associates, Hammurabi and Solomon, MB Kini, Media Partner, Lawstreet, and Associate Partner, Corporate Professionals, Madan Law Offices, Supporting Partner, Bombay Stock Exchange, Investor Protection Fund, the Legal Partner, Chandok and Mahajan, TSK Legal, and the Presidium Partner were Renew Power, SpiceJet, and TCI. Thank you so much all for your contribution, support, and participation, making the day wonderful. Thank you so much.
And thank you, ASSOCHAM, and congratulations for a wonderful program.